Hello. Oops. Good morning, everyone. Golly, this 1080, I just went and bought a 4K webcam. I don't think I'm going to like it. I don't think I like it already. I don't think I do. No, I don't think I do. We'll find out. We'll find out by the end of today. Good morning, everybody. How are you? I'm Patty Wilson. I have to leave shortly to go to the radio station. So we are going to play Melody Farris's It's Day 18, and closing arguments are today, which I'm going to miss most of it in the morning. So I hope you all take great notes. Great notes, please. Please, please, please. I have to interview a gentleman his name is Dr. Isaac Montilla. He's a chiropractor here in town, and he's a prolific chiropractor. He has several branches, several offices, and he is running for county commissioner. So this is election time of year. I actually have another one at 4:00 today for another gal. She is running for county judge. So I will be back and forth today, but I'll have my phones with me, and I think I'm going to take my, thought I was going to take it, my laptop. I might take it. Let's see. But anyway, how is everybody? I don't even know where my laptop cord is. I don't know what I'm doing today. I got here at like 7:30 to be ready for everything, and I'm ready for nothing. That was a mistake. It's just a mistake. Just a mistake. It's just a busy time of year for our office. We have the Veterans Day Parade coming up. We have our normal real estate transactions, trying to be part of a trial here. We got stuff to do. Good morning, everyone, and welcome. Eric Lieber, where were you yesterday? You were missed. You were missed, Mr. Lieber. Good morning, Lorraine. It's nice to see you. Oh, look at what Eric wrote. A pretty girl is like a melody that haunts you night and day from the Ziegfeld Follies. Yeah, I guess so. She didn't look good yesterday, did she? So this is Melody Walker Farris, and she is on trial for the murder of her attorney husband, who ended up in a burn pile and basically cremated, except for the final parts. The big bones, the skull, the femur, some ribs. Unbelievable. He was over 300 pounds and about 6'4", and nothing to be had. What did you all who were watching yesterday with me, what did you all think of Eric? It's not Dr. Arden, Arden, who was a paid for forensic examiner, pathologist. His claim to fame, he said, what is wrong with my... Oh, there we go. His paid for Chandra Levy. Like, that was 2001. I had to go back and look it up. Like, that was before I became a realtor, before I moved to Florida, like before a lot. That was his claim to fame. I was thinking he needed a chiropractor, to be honest with you. He was, let me turn this other light on too. I'm seeing all sorts of shadows in my office today, but it's very dark out. Hey, Beach Bum, how are you? Thank you for going to the courthouse. Appreciate you and Wesley. Wesley left me a very nice message yesterday, but we were both busy, so I didn't catch up with him. Good morning, Francis. Good morning, Pepper. Good morning, Claudia. You have a blessed day, too. Norma says, saw lounge bar crime where Dawn follows cases like Dan Markel. She gets fired up like Patty, but lives in England. So she uses closed caption. Sometimes I have to. I watch British TV if I'm going to watch TV, either Acorn or BritBox, and I have to use closed captioning for a lot of the people. What is that? God, so dark in here. It's this 1080. I'm going to have to work on that. Good morning, Angela and Linda and Shelly F. Happy hump day. You have no idea how excited I am for this week to be over with. Not because I'm here with you, just because of work. Just because of work. People are moody. They're moody. This is going to be a nail biter for you. Do you think, Angela, that she's not going to be found guilty? And you've already cleaned your refrigerator and your spice cabinet. Well, you have a spice cabinet, so that's pretty lush. I have not. I have got myself here. I got free coffee this morning from the McDonald's, so I was pretty happy about that. I like their coffee. Good morning, all. Patty Mods and all. My husband just said I should hurry up and go play with my friends. Oh, so nice. Yay, that's so cool. Juror number 123 reporting for duty from the 2. That's funny. That is funny. Joe Jordan, good morning from California. Goodness gracious, you're an early bird. Christina, good morning. I can't wait to hear the closing arguments to see how the prosecution pulls this together. I'm still disappointed they didn't do a rebuttal. I'm a big fan of, I'm a salesperson. I'm a real estate broker and a property appraiser. And if I can get in front of a client just one more time, I'm happy about it. So I'm really surprised that they declined that rebuttal opportunity. I really am. There was so much to rebut if they wanted to. Hey, Debbie, good morning to you. Thank you for being a moderator. The moderators are in charge today. Not that we get a lot of spam. We don't get a lot of spam. Susan wants to know what you're baking today, Joe Jordan. You had to book a haircut, the 2? I thought you were a juror. Fix that. Good morning, Joan. Welcome. Happy to have you. Mad Wabbit. Good morning. Happy to have you too. Thank you for joining us. Debbie says, I met a retired prosecutor from Pennsylvania last night at a meeting. I filled her in on how great this group is. She wants to get on today, but doesn't have a YouTube account. I forgot how I signed up. Bless your heart. Well, thank you for sharing about us. Present and accounted for, Beach Bum. Celia, good morning. Happy day, Patty. It's a happy day to sit here. But I'm excited because Wednesdays, honestly, are my favorite day of the week. I get to be at the radio station. I get to see Scott for a full hour. Scott, if you don't know, it's Scott Cowart. He's my business partner. He hasn't asked me not to use his full name, so I will use his name. We joked a couple days ago that my daughter's like, could you just not say my name so often? So I call her Ollie Mae now. So Ollie Mae's having a good day. Wesley, hey, good morning. You're here. Good morning, Frau Patty and chat friends. It's just lovely. Joe is taking the day off in the kitchen. Guess I figured out something. The sleuth that I am. So Guy Fieri, I told you I met him here's my box. I met him last Friday at my cigar shop where he signed my box that says good hair. And I figured out why he's here. So we have a little, let me pull it up. We have a cute little, what do I say? Like a little diner. His name is Leon Charles Brunson. And he has a little restaurant called, I'm going to put it up here, Leon at Lake Ella. It's super cute. And he applied to be on one of the cooking shows. I forget which one it is. Whatever one Guy's on, right? So he applied to be on here. And that is why it says here, Leon at Lake Ella on the 20th will be closed for service today to prepare for a special event. So that's why Guy came. So Guy came to record his opportunity. I forget which one it is that he applied for. But, so that's why Guy was here. He was here all week. He was here. He came to a couple liquor stores because I guess he has some like bourbon or vodka or something. Here he is. So that's Leon. He's absolutely adorable. And that's Guy signing the back of his baking dish tray. And then it's just absolutely adorable. So that's why he came to town. I was like, why would he come here of all places? And then I realized he had applied, and then he announced his opportunity to meet Guy and have Guy be on his show. So it's pretty cool. Everybody loves Leon. He cooks like lush food. Like everything's like foodie food. So congratulations to Leon. I think it was a big deal. Good morning here in Texas. We are hoping we really get some rain. Yeah, we haven't had rain either. I felt some like freaky moisture in the air. Good morning, Georgia Peach and Victoria Girl from Victoria, British Columbia. I bet it's absolutely beautiful there right now. Kimber, Sally, Norma. Patty has multiple phones. She does, but none are burners. So there is that. I've thought about it. Like maybe I should get a burner phone. Would be nice. Lots of law enforcement in the front row. Boxers are gone. Many family members. Thank you, Beach. Oh, man, I'm going to miss it. So pissed. Performance anxiety. You're funny, Eric. My sister, I won't say her full name. She was a professional dart player. My younger sister. Good morning, nosy neighbor. Our own very Gladys Kravitz keeps an eye on things in here. Keeps me on the down low. Good morning, Shelly. Taterbug is back. Taterbug is in the house. Rosemary, good morning. Wesley. $6,600 for nothing. That's how much that Dr. Arden cost. Kimber says, I definitely think there were other bullets in that man. Here's my, I'm going to play it later this afternoon, but that prosecutor, her name is Megan, asking that question. So have you seen where other bullets have entered a person and then just kind of landed outside the skin? It was a perfect question for a perfect person. It was just, let's make him sound as dumb as he looked. I'm sure he's not dumb, though. I mean, he is a doctor. Patty, I told you what I thought of his testimony yesterday. Not impressed with the doctor either, says Cannon on Hill. Georgia Peach didn't like him either. Well, there's a lot not to like. I didn't understand it. Over 11,000 has already paid 6,600, 4,500 and outstanding to be paid. Sounds like a sponsored witness. Well, all experts get paid. So, I mean, that's not really, it's like $700-800 an hour. Just for like, I know appraisers who get paid. I had the opportunity to be an expert witness, I think for Wells Fargo twice in a foreclosure, and it was lucrative. It just is. I was accurate, but it's lucrative. Good morning from Australia. And please like. I'm getting more used to. That's very Dutch of me, Pennsylvania Dutch. But I am getting used to asking for likes. I do appreciate it. We have amazing members. Everyone's really a member almost, right? It's just been an amazing experience, and I really appreciate it. I feel so old thinking of Chandra Levy. Well, when I went to go get my Diet Coke today at the Circle K, the 25-year-old date was like today, 2003. And I'm like, really? Good morning, Michelle Celeste. What a beautiful name. Rosemary, did you see the last Jibs and Jabs video? Wendy has her own dress decorating company for Charlie's house. And Patty, you're in it. I did not see it. I did not. I will go look, though. I'm going to go look now because I didn't see it. Hopefully it's a good that I'm in it. Guilty as charged, says Tia Bawa. Am I saying your name right, Tiabawa? Good morning, Jersey girl. Any big plans for Halloween? Mm-mm. I gotta find another trial. Good for you, Joe. You had to go drop off your ballot. There is a ton of early voting in February. Ton, which I'm grateful. Anyone, you just vote or be quiet. Claudia says the pathologist yesterday was a waste of time and money. The anthropologist is believable. And asking again about the copy and paste when the anthropologist already explained that, it doesn't make the report less believable because they copied and pasted it. He's not an anthropologist. Eat with candy. Hey, good morning. You are so right, Patty. They absolutely should have brought back Rusty. They should have brought back Rusty. They should have brought back Scott. That's my opinion. Because Scott was like the untold person in the room. So I thought they should have brought back Scott. Rosemary also thinks they should have brought back Rusty. Francis, I rolled off my bed and made it to my chair. Thank you. Good morning, Anya. I hope I get through everybody before I have to go. Moonchild Pink, good morning. Oh, there's movement. There's movement, people. So like I said, if you're new, because we've just grown, like we're up to 200 right now, 5 in Twitter and 195 in YouTube. I have to leave for a radio station. I'm recording a show today, which I do every Wednesday. And I hope the sound is right and everybody's happy because this is all you're going to get. So I'm going to turn it up really loud on my TV, which I think is helping. I don't know. Good morning, Gank Canuck. Nice to have you. Good morning, Doris. All these flowers in the feed, all these like emojis. I love it. Guy knows hair. He does. My hair is bigger than his. My hair is very big. Good morning from Moore Park, Carla. My brother-in-law lives in Moore Park. He occasionally watches me. Makes me very nervous when I heard that. Good morning, EB. Happy here for hump day. Amen. Good morning. Why don't you do a last minute poll to see who still thinks Melody will walk? Unfortunately, I believe she will get off. I can do that. Now that I'm learning more about YouTube, that's what I'm doing in my nightly fun. What husband? I have a trial. Fun. I have a trial, Christopher. Deal with it. It's my poor husband. Let's see. Okay, poll is started. Started the poll. Is she guilty? Is she innocent? Is she... Oh, let me make sure my display is not going to cut off. This computer updated, so I got to make sure my display won't shut down before I leave. Do. Energy saver. Yeah, I'll never. I just wanted to make sure the screen didn't shut off and I couldn't fix it. Oh my. My daughter was upset because he made an appearance at FSU. He shouldn't get her tacos because everything was shut down to prepare for Guy's arrival. Oh, I'm sorry, Shelly. Diners, drive-ins, and dives. Well, he's in for a contest, so I don't think it's that. I think it's something else. I forget which show it is. Let's see, Guy Fieri shows. Because I obviously don't have time to watch shows right now. But I don't think he's on Diner. It might be Diners, Drive-Ins, and Dives. I thought it was a contest he was going to be on, but I could be wrong. I could be very wrong. Oops, here we are. All right, so I'm going to mute me. I'm hoping for a Halloween conviction. Yeah, there's lots of law enforcement. It's a crowded day, isn't it? Beach bum, are they going to see if Melody can lift 300 pounds? You know, that was probably one of the dumbest statements ever. She helped me move a piano. Like, Thumper says, Patty, there's a wife on trial in Utah for killing husband, having affair. Her own parents now arrested too for cleaning up the murder scene. I'll email you the case name. Thank you, Thumper. Who doesn't love a good, like, marital bliss trial? Being in Cherokee County, Leslie says, guilty. If she was in Atlanta city limits, then I would be worried. And thank you for the text messages yesterday. Leslie sent me something about Martha Jane, but I actually went to sleep. I had fun last night. I went to go to Tallahassee Quarterbacks Club, had their event, and we saw David Pollack, who was recently on ESPN Game Day, but then he was let go, I guess, to bring out that Pat McAfee, whatever. But he was absolutely delightful. He was much better than I would have ever guessed. He was fantastic. So if you're in town and you ever want to go to the Quarterbacks Club, just let me know. It's fun. The next one and the next guest we have is Danny Cannell. And then our last one of the year is Doug Flutie. And that'll be fun. He's never been. And what the Quarterbacks Club does is then they give gifts. They give a little scholarship or little money, award money and prizes to the kids who our local high school players who do fantastic. And it's all voted on by the committee in Tallahassee Quarterbacks Club. And it's hosted by, his name is Hugh Tomlinson. And he does a fantastic job. And the food's great. Location's great. We get to see Doak. Super fun night. Super fun. Norma says, I feel like Scott helped, turned his phone off. Like, why did he check the burn pit? He did not help that woman. He does not like his mother. I think he's turned his Facebook off, but if you went and looked at his Facebook, the rage that this man has is pretty tactile. He really struggles with that is his mother. The two says maybe she was chasing him around the property. I think now and that's where Dr. Arden did not help. He was shot in the house, ran out of the house. She chased him. She got him, put him in the tractor and rolled it down. Did you guys see? I shared it on a community page. I'll play it later. It's Court TV's walk through the property when the jury was there. So the Court TV went and they did a walk through the property, and you see the proximity from the burn pile to the house. It was on a slope. It would have been a lot easier to get him down to that burn pile being on a slope. It's just Beach Bum says it's very crowded. We do have subscribers in the room, which is amazing. And I have like 2 minutes before I got to run. So fun. Gladys, yes, I love polls. Good morning, Mel Tool. How are you? Jersey girl hair. I do have Jersey girl hair. That is true. High and tight. Eat with Candy. Love from Toronto, Patty. I'm so glad I found your channel. Thank you. Beach, 300 pounds of fertilizer. Is that the defense? Oh, my. Jennifer Gledhill. Thank you. I have my little notebook nearby. Yeah, if you don't know, I take notes. If you don't know me, again, I'm Patty Wilson. This is Patty's Playhouse. I'm a real estate broker. And I take notes during our chat sessions. And I also, as they say, pull things up on the fly. You know, I like to do research. You don't know because you just met me. But I like to do research. And it's fun for me to look things up while we're in here. And if Chatter or somebody in the membership, we call them Patty Cakes and Patty Melts, has a question, I'll look it up too. Debbie says, right, because any doubts from jurors would be on Scott's involvement in the wired calls from Rusty. I think they should have called them both back, if not for my own entertainment. What are all of Melody's charges? Oh, you've got to get me on that. Get this. There's sights down. Oh, there it is. Came back up. Okay. This is her charge. Malice murder, felony murder, aggravated assault, concealing a death of another, and false statements.
All right, let me see it.
And they're about to start, and I'm about to leave.
Y'all get a chance to look over just now was able to get y'all a printed copy, but I sent y'all electronic copies yesterday. Were y'all able to review the charge and were there any issues we needed to take up?
I don't believe so.
No, we just stand around objecting.
All right. All right. There were a couple. I have this little guide on the top that there were a couple that I went through and dropped out last night. I emailed you on one of them. I don't remember what the last one was. think it was a simple assault, reasonable fear language. I took that out, and I took that out of the aggravated assault charge as well, since it's not charged that way. All right, with that, are y'all ready to proceed? Anything else we need to take up before we bring the jurors in?
No.
All right, bring them in. We will. We'll see if they need a break when you get done with your opening. If they don't, then we'll let y'all go for about an hour, and then we'll take a break, and then we'll let y'all conclude, and then we'll hopefully be close to lunch break by then, I think. I don't know what time. No one talked to me about the food getting here. Let me know. We haven't had. All right. We ready to proceed to closing statements?
Yes, Your Honor.
And Ms. Farris, you intend to go first and last?
Yes, Judge.
All right, ladies and gentlemen, Georgia law allows for the party with the burden of proof to go first and last for closing arguments. So Ms. Frankish will get an opportunity to talk to you twice. Mr. Ray and Mr. Weaver will talk to you in the middle. I believe Ms. Frankish is going to handle the closing arguments for the state, and Mr. Fogus is going to do his best to remain silent. If he needs to say something, we'll probably give him the opportunity, but I believe Mr. Weaver and Mr. Ray want to split theirs up and want to both talk, and that'll be fine. I anticipate what's going to happen is Ms. Frankish is going to go for about 30 to 45 minutes, and then save an hour and a half or so for her final close. If we need a break in 30 minutes, we'll take a break. It's going to be a long day. Y'all are going to be sitting there listening for a long time. If y'all need a break, if we need this, y'all need to go reload your coffee, that's fine. We'll do it. I've told Mr. Weaver and Mr. Ray that we will stop about halfway through theirs regardless, and we will take a full break at that point and give y'all a chance to walk and stretch and grab a cup of coffee. We will go till When defense finishes their closing, it should be right at noon. We should have food available for you. We'll take a 30-minute lunch break. Then we'll start back with Ms. Frankish will resume her closing statements. Then we'll probably take another short break, and then I'll give you the jury charge. Then y'all will have the case. It's going to then take us we did a pretty good job yesterday at gathering up all the exhibits and everything for you, but we'll still have to get all that out there, but I'll give you instructions for that. There will be another break before y'all jump in and start deliberating, just so y'all know. And we'll also have to talk to the alternates and give them instructions. All right, with all that, Ms. Frankish, you can go ahead.
Thank you, Judge.
You have a power cord hooked up to the laptop?
Yes. Oh, the power cord? No, but I have
Yeah.
USB.
So yeah, power, it's your display is going to sleep. So plug a
it's
power
not.
cord into the laptop. It's on it's on the screen.
I know, I have a privacy. It's
Okay.
the audio that's not
Okay.
playing.
Oh, is it not playing audio right now?
Maybe
Okay, all right. We need to be on the same page.
Okay. All right. And so I don't want to be confused. But I remember you telling me he's on the burn pile.
Mm-hmm.
Were you lying about Scott? Is Scott, I mean, you think what? You tell me what happened.
I can tell you that there should not have been as much damage as there was done.
I don't know what that means.
That body should not have been burned up.
This case is about Gary Wayne Farris. And you're here because Melody Farris shot him, concealed his death by putting him on a burn pile on their property like he was trash. This is not a chess match or a well-played orchestra, as Miss Farris would lead you to believe. This is murder, and it is not a game. Murder is the highest crime we have, and it is your duty to hold people accountable when they commit that crime. Murder does not happen often in Cherokee County. You are in a unique position as a juror, as a Cherokee County citizen, to make sure that remains the case. And to hold people accountable who commit those crimes in your county, to your citizens. You have heard 3.5 weeks of evidence, maybe 4, I've lost count. But today, I'm going to go over the law with you and how you apply that law to the facts and the evidence that you've heard. The law instructs you to determine the facts. The facts are for you to determine. We have presented you the evidence, the witnesses, the exhibits, but you get to determine what happened in this case. And then you will apply the law that the judge instructs you to those facts. You are bound by the law. After the judge instructs you on the law, as he stated he will do for about 40 minutes or so, you will be armed with not only all of the materials that we gave you, the evidence, but you will also have the tools, which is the law. You will be in the position to convict Melody Farris. We talk about duty a lot, a juror's duty. You took an oath. The object of the discovery, the object is the discovery of truth. It is your duty to seek the truth of what happened to Gary Farris. You are not to seek doubt. All of the evidence before you points to her guilt. It is not your duty to go through all of that evidence, to find all the holes that are unreasonable, and to come up with some hypothesis that it doesn't even make sense. Your duty is the truth. And see, the defense wants you to ignore all the evidence that points to their client's guilt. They don't like the truth. They're going to lead you in a different direction. That will not make sense. That is not reasonable. Stay on the path of truth, and you will come to the conclusion to convict Melody Farris. The defense is going to talk about the state's burden of proof beyond a reasonable doubt. As the state, we have to prove a case beyond a reasonable doubt. But that is just that, a reasonable doubt, the doubt of a fair-minded, impartial juror seeking the truth. If there's a doubt in your mind, it has to be reasonable to acquit. It cannot be a doubt that makes no sense that you have no answers for. That's not a reasonable doubt. And in this case, we have proven it beyond a reasonable doubt. All of the doubts that they're going to get up here and try to plant in your mind are not reasonable. And the evidence shows that. And the law demands it. The defense is going to want you to believe that this standard is unattainable. They may even show that stair-step picture that they showed an opening of each burden as it gets higher and higher with reasonable doubt at the top. You cannot define reasonable doubt with steps. It is defined in the law. It is not to a mathematical certainty. It is not beyond all doubt. Beyond all doubt is unattainable. Crimes are not committed for everyone to solve and know about every single detail. Crimes are committed and concealed because no one wants to be caught. That's what you have in this case. No square circles. Essentially, that's what the defense is going to want you to figure out. How to make this circle into a square. You can't do that. That's impossible. The pieces fit together and they show the truth. We asked you in jury selection about your experiences in your life, things that you've been through. We are asking you to bring your common sense and reasoning into that deliberation room. Do not leave it behind. Because common sense and reason gets you through life. That's what you need to apply to this case. You make inferences, you can make deductions, and reach the conclusions based on what you know what you've experienced, the evidence, your common sense, that's how you'll reach the verdict in this case. In the beginning of this case, you were informed that you must be an impartial juror, not biased to either side. Impartiality. That's the starting point. And that she has the presumption of innocence. Well, that was 4 weeks ago. That was before you heard all the evidence. That was before you actually realized that she's just cloaked in all her lies. You no longer are impartial. You have all of the information, all of the evidence. And that leads to one conclusion, which is that she's guilty. She is no longer presumed innocent in your eyes. That is no longer where she sits. There are two types of evidence that the judge will instruct you on, direct and circumstantial. A lot of shows and podcasts and commentators, they all say, well, it's just circumstantial. Right? We've all heard that. But the law says you give whatever evidence, whatever weight to whatever evidence you want. There is no legal difference between circumstantial or direct. You could have the most convincing circumstantial evidence, and yet the direct evidence is just, well, maybe. Or you could have evidence that's actually both. Let me give an example. I have a 3-year-old, and the other night he was eating dinner at the table, and I ran upstairs to go get his sister's pajamas or something. We have a box of cookies on the counter by the cookie tin. They weren't in the cookie tin, they were in the box. And I come downstairs, and he had crumbs all over his face. There was a cookie missing. And so, based on that circumstantial evidence, I could infer my child stole a cookie out of that cookie box. I'm not going to infer that some cookie fairy came into my house and took it. That's not reasonable. But that is circumstantial evidence. Now, had the box been knocked over on the floor and the crumbs sitting there on the floor and my dog is laying on the couch licking his paws, well, that scene points to my crazy dog probably jumped on the counter, got a cookie out of the box and ate it on the floor. I don't have to see who took the cookie to know who took the cookie. And the scene leads me to believe it's one or the other. Because I know my child and I know my crazy dog. So circumstantial evidence is a conclusion that you can reach based on inferences. Direct evidence is something you heard, saw, tasted, smelled. Scott seeing blood on the floor in the basement. All of the testimony you heard, those are things that they experienced firsthand, the witnesses. It's direct evidence. There is no legal difference. You give whatever weight to whatever piece of evidence you deem appropriate. You get to determine the credibility of all the witnesses in this case. To do that, you can consider all the facts and circumstances of the case. And on the next slide, there's going to be a non-exhaustive list of other factors. In this case, motive, bias, all of those come up. Scott, Emily, and Chris will not get their father back. Whether they get up there, they have no motive to lie to you. because Gary's not walking back through that door. That's their mother. They have no reason to lie. They don't want this. They don't want her sitting there. They don't want Gary gone from their lives. All they wanted is for you to have the truth. Martha, she is the epitome of a credible witness. Look up credible witness in the dictionary. It's a picture of Martha Barton. She loved Melody. She knew it was the right thing to do to come in here and tell you people the truth, because you need to know the whole story. She had no motive to lie. Consider all of these factors when you're giving credibility to a witness. All of the facts and circumstances which they testify, their manner of testifying, their means and opportunity of knowing facts, the nature of the facts, the probability or improbability of the existence of that fact, the interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. You actually weigh people's credibility every single day without really thinking about it. You choose who your friends are, you choose who you want around your family, who you hang out with at work. You decide that based on a person's credibility. This is no different. The nature of the facts, the nature about the facts of which they testify, let's talk about that for a second. David, Melody's friend, who came in here talking about his one experience with Scott in the driveway in the trailer, he didn't really have the means and opportunity of knowing the facts surrounding that situation. He knew Melody for like a second. Scott didn't know who he was. You know what Scott knows? Scott knows Melody killed his dad and is running around with Rusty Barton still and letting strangers over to the house and throwing Christmas parties. Yeah, he's gonna be mad. His dad was just murdered and burned up in a burn pile on his own property by his mother. And now some strange man is coming and using his trailer. He's gonna be mad. David had no perception of that. Zero. And he has an interest in the outcome of this case. He doesn't want to see his friend go to jail. We've talked about this. You must apply your common sense and reason to decide what testimony you believe or don't believe. Again, you weigh people's credibility all the time without even knowing it. The law allows you and demands that you determine who to believe and who not to believe. And some people, you can believe some things they say and not some things they say, right? Like Rusty Barton. He plays both sides. We know that. We saw that. He wants to stay out of trouble, yet he doesn't want to upset Melody. We know what he said was the truth about her statement, he's in the burn pile, because of the context in which he said it. We know the recantation is a lie because it makes no sense. Why, if she gave that statement at Martha Jane's house after Gary's remains were found, why would Rusty respond with, "Don't tell me anything else"? And he references that 2:20 a.m. call. And then the call you just heard, he references it again. And that was August 2nd of 2018. That is a witness. You'll have to resolve the conflicts of his credibility. But he was up there long enough. Y'all know the kind of person he is. Use your common sense and reasoning. Now I want to talk to you about what she is charged with in the indictment. And you'll have a copy of the indictment in the back with all the charges in it. I'm going to start with 4 and 5. We've got malice murder, felony murder, aggravated assault, concealing the death of another, and making a false statement. I'm going to start from the bottom and then go to more serious charges. Okay. First of all, let me say this. If the defense doesn't get up here and concede making a false statement, no credibility to their closing argument. Knowingly and willfully making a false statement in any matter within the jurisdiction of the government of any county. Like Michael Ray said in his opening, lying to the police. I lost count how many times that woman lied to those police. But specifically this charge is about being currently in an affair with Rusty Barton. And y'all heard that voicemail on June, I think it was 25th. It was like less than a week before Gary's remains were found. Call me back, love you. That affair didn't end a year before. She just saw the unraveling. She didn't even own up to any affairs. She lied about Ted Wiley. Oh, we were just friends. We were all just friends. We know that's not true. You literally left your husband and went to stay with him for a significant amount of time. And he had to take the stand and talk about their relationship. If they don't get up here and concede that, you can't give their closing any credibility. Concealing the death of another. Commit this crime by concealing the death of another, hindering the discovery of whether or not such person was unlawfully killed, i.e., putting a body in a burn pile to conceal that he was shot to death. Concealment. Now we're going to go to count 1, malice murder. Causing the death of another person, in this case Gary Farris, unlawfully and with malice aforethought. Malice. That's what this charge is about. Malice is doing something maliciously, which means you have an abandoned and malignant heart. Malice can be formed in an instant. Now, we have a lot of evidence of malice in this case. Malice is not premeditation or anything like that. It's not ill will or hatred, although we have hatred. She despised Gary. That's no secret. She intended to kill him without a legal justification. The state does not have to prove premeditation, although we have evidence of premeditation in this case. Taking that gun from Martha, telling Addison not to spend the night, she knew this day would come. There is no required time to form malice. Like I said, malice can be formed in an instant. Every time she saw Gary, she had malice. Felony murder is another type of murder, which essentially is when you cause the death of another during the commission of a felony. And in this case, that's aggravated assault. Aggravated assault will be defined in the next slide, but it's shooting someone or pointing a gun at someone. That's aggravated assault. And that caused the death of Gary Farris. We do not have to show in felony murder that Melody acted with malice, even though we know she did. This charge does not require malice. It just requires the commission of a felony and someone resulting in somebody dying. The judge will instruct you aggravated assault is a felony. There needs to be what's called proximate cause to the death. So the felony has to have resulted somehow in the death or be connected to the death, which we have. The judge will give you a definition of a simple assault, so you know what assaulted means, assaulted another person with a deadly weapon. And he will also instruct you that a firearm legally is a deadly weapon. We do not have to prove injury, although we have that in this case. It's not required. You can assault a person by instilling fear, but that's not what we have here. We actually have a shooting and we have a death. I want to talk about the state's burden. Like I said, reasonable doubt cannot be measured. They will want you to believe that that burden cannot be reached and it is unattainable. They will get up here and try to instill upon you that there's no way we can ever prove this case beyond a reasonable doubt. Well, that is just not the law. The law does not require beyond all doubt. We need order and justice, and that means we prove a case beyond a reasonable doubt. You have more than what you need in this case to convict Melody Farris. I want to talk about grave suspicion and mere presence because I assure you that Mr. Ray or Mr. Weaver will get up here and talk about how we just have grave suspicion of Melody. She was merely present at the home when he died. No. We have way more than that. What they have is a grave suspicion of Scott, which is based on speculation and conjecture. And that's what that charge says. You cannot convict on speculation and conjecture. We can't even indict on speculation and conjecture. That's not even probable cause. Mere presence. Scott wasn't even merely present in the home. He was merely present at the barn. Compare the two, right? Grave suspicion, mere presence. Scott Farris. They have suspicion based on what? He's 6'5". He has a messy apartment. He was in the military. I'm sorry, is that a suspicion these days? Do we have to suspect everybody in the military is a murderer? Grave suspicion, speculation, and conjecture. That's what they're going to throw at you about Scott Farris. That was all their defense witnesses. Well, I just didn't like the way he talked to me. Well, I'm sorry, his dad was brutally murdered by his mother. I think he's allowed to be angry. But Melody, we're here because Melody is sitting in that chair. And we have proven beyond a reasonable doubt that she is the one that murdered Gary Farris. The judge is going to instruct you on what impeaching a witness is. It's essentially showing that a witness is unworthy of belief. You attack the credibility, and he'll give you all those charges in the jury charge. We saw some of that here, but the persons whose credibility that was attacked the most is Melody's. I mean, you saw Amanda sit on that stand, and Mr. Fogus showed her the text messages of Melody lying to her about going to Minnesota. Did you see Amanda's demeanor? Betrayal, disappointment. That's attacking her credibility. She's not worthy of belief. Amanda knows that. Her other children definitely know that. They sat up here and told you that. To that same vein, consider the source of a witness's information. If that witness's information is coming from Melody Farris, it is not worthy of belief. That's how you impeach someone. Every crime must be committed with criminal intent. To determine criminal intent, you can consider words of the defendant, conduct, demeanor, motive, and any other circumstance that you deem relevant. We have a lot of intent in this case. We even have a text message where she says, I told him I hope you die a gruesome death. If that's not direct evidence of intent, I don't know what is. Her demeanor when she found out about Rusty's statement, she was angry. She was mad at him. Her motive, she had plenty of motive. She's the only one that had motive. I've said this. She despised Gary. She hated that he was giving away their money, her money. That was the main motive. Rusty was a bonus. She was mad about that money. And you could tell that was her motive because after the offense, she was on a money hunt. It was all about the money. We'll get into that in the next close. Telling Addison not to sleep over, she had criminal intent that night to kill her husband. And she, one, didn't want witnesses. Two, never told her grandkids that they could not spend the night. Telling people to, shh, I thought I told you to stop talking. Everything she said and did in this case not only proves that she committed these crimes, but she did it with malice aforethought and an abandoned, malignant heart. She stood to inherit all of his money. She burned the remains of her husband for almost 39 years in the hopes it would look like an accident. All because she wanted his money and to live a life with Rusty. In my next close, I'm going to talk about the evidence and why the evidence and the law demands a verdict of guilty in this case.
Let's go ahead and take a quick break. I'm going to try to set up another microphone over here. All right. So we will try to keep it to 10 minutes. And y'all can go run down and get a cup of coffee if you need to. You can come unlock this. to direct the audience that unless you're a member of the media, you cannot have your phones out. And I don't generally get bent out of shape about things when the phones go off during court. I just pretend I don't hear it until it goes off the second time. But if your phone goes off, you'll be removed from the audience. So, but media folks can have yours out and can be taking notes or whatever, but members of the public who have not filed a Rule 22 may not. All right. So make sure you have it on mute, and if you're not certain, or if you have some monitor like I do that will go off even if you have it on mute, turn it off. Well, I didn't put it back on after the other day, so I can do what I can eat whatever I want at the moment. All right, Mr. Correa, go ahead.
May it please the court, opposing counsel, ladies and gentlemen. First off, on behalf of Mr. Weaver and Ms. Farris, thank you very much. I know that this has been, for y'all, a long 4 weeks, and definitely for all the lawyers, it's been a long 5 weeks of dealing with this case. And we note that you have been paying diligent attention, taking your notes, and we are very appreciative of that. And with that, and like I told you on October the 7th, when I did my opening statement, you're getting on the Ferris wheel. And it is, in fact, this family is a soap opera. And I think through the testimony that you saw that. Now, first off, the indictment, Ms. Frankish went over the indictment with you, so I'll just touch on it briefly. Count 1, malice murder. Count 2, felony murder. Count 3, aggravated assault. Count 4, concealing the death. And count 5, making false statements. Now, this is just to point out, Ms. Frankish pointed out that, we're disingenuous if we don't just get up here and freely admit about count 5 making a false statement. So I'll just go ahead and give you a preview that Mr. Weaver is going to be coming up with. He does not have a PowerPoint. He's got 2 books and about 10 pieces of paper, and he's going to be specifically addressing that with you. But what I will be doing in mine is walking you through what the actual physical evidence was in the case. And we're actually going to start by walking through the front door of the Farris property. Now, first off, with reasonable doubt. Reasonable doubt is the doubt of a fair-minded, impartial juror honestly seeking the truth. Ms. Franklin said it to you. I said it to you in opening. The judge is going to say it to you again. Mr. Weaver is going to say it to you again. And Ms. Frankish was right. There is a stair step. I found that several years ago, and I have used it ever since, and I absolutely love it because it shows what reasonable doubt is. Because you're not finding this case and deciding this case based on reasonable doubt. It is beyond reasonable doubt. So it's a doubt that you can give a reason for. They have to go beyond that. They don't just get up to the reasonable doubt step and stop, because that's not guilty. They got to get up on that top step beyond that doubt. And it is a long burden. Look at all the stairs, no evidence until a reasonable suspicion, probable cause, preponderance, clear and convincing, reasonable doubt, and then finally beyond reasonable doubt. They have not come even close to beyond reasonable doubt. The state has introduced a case to you and spent 4 weeks presenting evidence, and it is so full of holes, and we're going to go through all of those. Remember I told you about when John Luke and I were getting ready for this case, and he had kind of hit a wall that day. And he was like, I'm leaving. I'm done. Can't listen to any more interviews. There's so many hours and hours of interviews in this case. He was like, I'm leaving. And he went to the drugstore close to our office. And he was just talking to the clerk there. And she said, well, sometimes the Grace's questions go unanswered. Came back in rejuvenated the next day. We're like, hey, we got a theory, because we do have a lot of unanswered questions. So what are just some of those? The questions that have no answers in this case. How about the easiest one? Where was Gary shot? All right, if you remember from that drawing from Dr. Gooding, and I'll show it later, he could have been shot here, but she also said he could have been shot here. They don't actually know where he was shot. They don't have an entrance wound. They don't have a wound path. They don't have an exit wound. And in fact, and I'll go over it more later, Dr. Arden stated that the bullet is lodged in the soft tissue, never entered the body cavity. In that fact, that bullet that they found in the burn pile, there's no way that it would cause death. It would cause some bleeding. He said it could possibly bruise the lung. But in his medical opinion, it's impossible that that bullet caused the death. How was he put on the burn pile? This trial started out, it was a week of establishing the fact that they have a tractor. And there are now hundreds of photographs of a tractor and an RTV. But how did he get on there? And we'll go through what the tractor and the RTV shows. Where is the gun? No idea. How about where are the bullets? No idea. Scott's odd behavior, and I'll talk more about that shortly. How did Gary even die? And that ties into where Gary was shot. You heard Dr. Arden say that he would have to say that the manner of death is undetermined and that the cause of death is undetermined. And he said that because that was his medical opinion. And he was very clear in stating that I am saying this because I just do not have the facts. And I have not been given the facts. And the state hasn't shown me the facts to be able to make to a medical certainty of what the cause of death was and the manner of death was. And there are countless others, and we're going to be going through several. So, walking through the crime scene. This is the front door of the Farris home. You'll remember from talking, or from the testimony of that point in time, he was an investigator, now he works at the school. Shaw, you remember him. Shaw stated that he was brought back in, because I don't think he can remember who told him to, but there was a blood droplet. I don't think my little pointer will work on the TV, but it's right there, kind of underneath the window in the middle of that hallway, that there was a blood drop, a potential blood drop. But what ended up happening, that blood droplet was not collected or tested. And actually, when they brought Agent Coffey out, or Agent Honey, they didn't even have her blue star it either. So there is a spot on the floor of unknown origin, and nobody knows actually what it is. Moving further into the house, into the dining room, and you'll remember, if I am facing this photograph, the door to the stairs to go down to Gary's living quarters, it would be to the left. Agent Honey sprayed this entire area, if you'll remember from her testimony, in blue stars. Nothing. Not a single drop of blood, except for when you turn and on that same rug. That's the rug there, and that's up toward what would be the left-hand corner of the rug. There's a single drop of what she said is possible blood because it reacted to the blue star. Wasn't collected, wasn't tested. I asked her, I asked Shaw, I asked Stewart, can you take that, can you cut it out? Can you swab it? Yes, yes. Have you ever done that before? Yes. Did they do it? No. They didn't do anything. They literally took a photograph of it and said, well, good enough. And you're going to hear a lot of that in this case. It all seems as a lot of good enough. And actually, they came in and they're sitting on the front there, which is perfect. Because a lot of them, if you heard us when we were questioning them, it's like, why didn't you do that? And what's the answer? I wasn't asked to. Well, when you're the government and you're investigating a murder, you should have some decency to actually take initiative in this case, especially if you're going to accuse a woman of murder. But they don't have any initiative. In fact, they had Kuykendall over there standing next to a tractor at 8 o'clock at night for no reason instead of actually investigating. They abandoned, and of course, Hayes ain't getting off the hook that easy, but that sheriff's office, they abandoned Hayes. They went out there and they investigated that crime scene and they left And then they just said, Hayes, you know what? You're the lead. It's on you. Figure it out. And just left it. That's why Pope had to go with him to Tennessee. He don't even work for the sheriff's office. He's an investigator with the fire department. And he goes all the way to Tennessee to interview Martha Jane, I believe, and also Rusty Barton, because he was left. But so there's no initiative. Agent Honay says, when I asked her, did you collect it? No. Why? Nobody asked me to. No initiative. Here's the other blood spot, and this is two separate photographs. One on the left is essentially how the photograph is taken if you just took it while we're standing here today. The second one is you turn off the lights, and you remember with Shaw how you got to manipulate the lights, and then I did the whole thing about instead of taking a photograph and manipulating it, why don't we just set the stage in the house to actually be able to show the luminescence of the blue star actually on a photograph instead of manipulating the photograph to maybe see the blue star. So that one's been manipulated, but that's fine, because what did Honay say? It reacts like blood, but it could also be something else. Because remember, I went through with her different types of food that can react to blue star, different type of chemicals that can react to blue star, different type of minerals that can react to blue star. So she said, I don't know what it is. And also, did they sample or collect it? No. So essentially what we have here is a photograph of something that proves nothing. The stairs were the same way. I was going to go in, put in the blue star on the stairs, but, not just going to sit here and beat a dead horse. They didn't do anything with the stairs. They said, well, there looks like blood. Well, we're not going to collect it and we're not going to test it. So good enough. Now the downstairs, we actually get some investigation going here. You see from 1, 2, 3, and 4. You heard with the GBI that essentially we were calling 1 and 2. That's EM1 and EM2. And that's just EM was evidence marker, so 1 and 2. Now, those blood droplets are the DNA, blood DNA of Gary Farris. That is proven. That is a fact. 3 and 4 were not collected nor tested based on the testimony of Shaw and Thrasher and Hayes as well. Side by side, up close comparison of EM1 and EM2. You can see the blood droplet of EM1 is a centimeter, a little bit smaller. EM2 is those tiny, substantially less, less in size than a centimeter, 3 little droplets. Now, the basement. We talked a lot about the basement. So I just put that in there from a backed away perspective of this. You can see there where the arrow is, that's about where EM1 was. It's essentially at the foot of that wooden spiral floor lamp. The projectile that was found in the basement is in between the cushion and the chair. And there's a close-up of the projectile. Now, here's what's interesting about the projectile. The projectile, they testified, did have DNA of Gary Farris on it. And I believe that they actually tested a piece of skin. That's what the testimony of that was. But look at that bullet. It's in a very peculiar spot. According to all the witnesses that testified, there's no impact marks, there's no bullet holes, there's no nothing. There's no marks on the ground where this bullet landed or anything like that. And then when Honay got on the stand, because remember she blue starred the basement, and also with Kuykendall, since he's the one that found the bullet, no blood found around that bullet. The only blood is EM1, 2. That's the only blood in the basement. Around that bullet, there is no blood. So there's no blood found anywhere around the projectile. Now, Honay said she blue starred it, the whole basement. I'll show you another photograph here in a second. And also the GBI quantified that they examined the bullet and there were no textile fibers found on the bullet. And if you'll also recall with, I think her name was Bagwell with the GBI, talked to her about how a bullet can go through, especially with those types of bullets that you saw. And you'll have it back there. You'll see that the flanges that kind of go out, kind of got, almost looks like kind of teeth on them where the bullets opened up. And they talked about how that can go through and snag on clothing and things like that. You can get fibers and other types of materials on the bullet, of which they found 0. Now, showing the basement out again, the little area, that's where Hone blue starred. And I asked her specifically, did you blue star on the couch and the chair and all? Her testimony was, and you'll remember this as well, was that she believed that she had blue starred the whole basement, but she would only take photographs if it showed the luminescent or presumptive blood. And she had no photographs of the couch. Nothing. Up here, any of the walls, and this applies upstairs too. Nothing found. Nothing found on the back walls, nothing found on the ceiling, nothing. The only thing found, 2 less than a centimeter drop of blood in the basement. Now, this was admitted through Thrasher, I believe, essentially, and this is a pivotal piece of evidence because when you're looking at the photographs, it's kind of hard to figure out, especially for you guys who hadn't been there and seen all this stuff, of actually trying to navigate that house. Very confusing, especially when you get in the basement. But you can see, and you'll have this back with you as well. This is the main floor layout, and you got the porch and all that. And I've taken this and I've put the little dot. So that first dot closest to the bottom, that's where they said they thought was blood, but they didn't do anything with. Then you move around and you've got nothing until you get to that little drop at the top of the stairs that Hone talked about, as well as Thrasher, and then that other kind of swipe mark closer to the family room and the drops going downstairs. Now, what I thought was interesting in this, and the reason for it is, so you supposedly have, because you'll remember Mr. Fogus asking, I think he asked Hayes, did you have evidence of a violent crime being committed in this house? And he said yes. Okay, so that's your evidence of a violent crime. 4 supposed drops of blood that was never collected, never tested in this entire, y'all saw the house. It's a pretty big house. But where else was nothing found? Or what else was found? So we got the living room, there's nothing. Kitchen, nothing. Breakfast area, nothing. Little hallway that leads to the bathroom and the mudroom, nothing. The hallway leading into the dining room, nothing. The dining room, there's just that one little drop that they didn't collect on the carpet. But other than that, nothing. Study, nothing. And most importantly, or second most importantly, that's the hallway that leads out to the garage, 0 found. Front porch, 0 found. Going downstairs, that's EM 1 through 4. You can see I've labeled it, the top 2 kind of bigger ones. It is hard to make a circle with a mouse attached to your keyboard where you just got to do it with your fingers. So pay no part of that. But also down here, so we got that, and we also got the projectile, right? So let's not forget that. But what else we have? Well, we got nothing found in the media room or the workshop. We got nothing found in the bedroom. Nothing in the office, storage, utility. Nothing leading out of those sliding glass doors to the outside. And nothing leading out upstairs, going back again, don't do that, leading out the front door. This is different. And also, you remember I asked, I think it was Shaw, and he hemmed and hawed around most of the stuff I asked him. But there's no damage to any of the doors, leading in or out of this house. So, any evidence of any dragging or any equipment being used or anything like that, and we'll get more into that later. But there's no damage to any of the door frames, the doors themselves, nothing. Now, this was, I think, aerial, one of them. And I put a little campfire, so that's my burn pile. All right, and that's a rough estimate of where it was. Y'all recall, y'all all walked down there. But what I wanted to show you is using this photograph is, so here, no blood is found. Here, no blood is found. Around the burn pile, no blood. No blood, no blood, no blood. Not a single solitary drop of blood from anybody. Melody, Gary, no one. And we'll go into the tractor, because you're probably like, well, what about the RTV and the tractor? We'll get to that. So that just shows all of those law enforcement. I could name, about who was there. Hayes was there, Shaw was there, Thrasher was there, Eckhart was there, I think Hands was there, Ballard was there. All of these people, all of these investigators, all of these law enforcement officers, EMS was there, fire was there. All of these people, and not a single solitary drop of blood is found on the outside where they claim that a violent murder happened. The outside of the house. This came up because you've heard, probably didn't know what a preliminary hearing was. There's no point to learn it now, but you heard Melody, you heard Amanda talking about it. I learned it at the preliminary hearing. And one of this photograph became a big deal actually in the preliminary hearing, because you notice you can see the crime scene tapes. So that is actually taken on or around July 5th. And I know the grass is extremely different now than when you all went out there. That is actual, real, regular old grass. Not a single tire track, drag mark, none on that well-manicured grass, or the surrounding mulch, or anything else. In fact, well, there's the photo. We'll go on into that. So, we spent a whole day establishing tractors. So we got the tractor, and then we tested. Or actually, Cockendall stood by with it for some reason. I think Stewart actually found a photograph on the left. That's the blood drop that was Gary's. That single, solitary, tiny little blood drop on the step. Because if you actually look at the tractor, there's no step on the, what would that be? If you're standing behind it on the right side, there's no step. So this is the left-hand side of the tractor, and that's all it is. Now the other photograph, that's the Blue Star photograph that Hayes and Shaw took when they actually took the tractor and the RTV over to the sheriff's office. And they said that this was, number one, it wasn't collected or tested, running theme we have here. But they said that was indicative of blood because it illuminated. But then, out of nowhere, I've been here for 4 weeks, and then we call the chief deputy. I didn't know it was the chief deputy. Thought he was still a captain. Found out he's the chief deputy now. We got promoted. Found out, why did you call in the GBI? And I was going to ask him that anyway because he was the head of CID, so he had to be the one to approve it. And what did he say? But our Blue Star expired. So there's now evidence that the Blue Star that they used in this investigation was actually expired, and that they believed that it was necessary at that point that they needed to call in the GBI to do Blue Star testing because they didn't have any that wasn't expired. Nobody told you a single word about that, and all of the testimony about Blue Star by the sheriff's office until Pinion came and said, no, I called in the GBI because we didn't have any that was good. Not that it matters anyway, because yet again, not collected or tested. Now, the bucket. No blood, no DNA, zero evidence whatsoever. There is nothing that indicates that tractor was used to move Gary Farris's body at any point in time other than a tiny drop of blood on the stairs, and there's plenty of evidence that Gary used the tractor. In fact, it was his tractor. He can use it if he wanted to. And there's a tiny drop of blood on it. But where we're talking about a murder, we're talking about moving a 6'5", 300-pound man, we got to have a way to do it. Use the tractor. Nothing. Somebody that the state says was shot 2 or more times, and there's not a single, not blood, not skin, not sweat, not hair, nothing found in the bucket of the tractor. Also, the back. I was just thinking last night while I was putting this together that, maybe they tied a rope around it, and we'll get into ropes and stuff later, but on the back of the tractor, nothing. Blood, actually no blood, suspected blood, or DNA, or any evidence whatsoever on the back of the tractor. So the front has nothing, the back has nothing. Now the RTV kind of shifted, and then it seemed to me like in the middle of the trial almost, or not necessarily in the middle, but during the physical evidence part, that things kind of twisted. It was, well, we've got to abandon this tractor idea because that's not really working out. We're switching to the RTV. It's a little easier. So, of course, we got a Blue Star tested too. But there was, Melody's blood was found in the GBI testified to this on the L2 shifter. There was no other blood or other DNA found on the RTV. Now, here's what's interesting though. L2 shifter, that's how it's labeled. You'll have a copy of the GBI report back there with you. That's what they call it. Problem is there's zero evidence or photographs of it, of the interior of the RTV, and nobody testified what the L2 shifter is or does. We have no idea. I don't know if that's what makes it go front and back. No clue. It's just called the L2 shifter. Now here's the Blue Star, yet again expired, on the RTV. So it is very hard to see, but so I put the circles around it. So that is on the, we'll go with the left side first. That's on the, looks like the driver's side of the Kubota. Those little drops. They said that was presumptive of blood. Then on the back, where that indention is on the left-hand side, there was a little blood there, or what they thought was blood. Now, then keeping the theme of this case rolling, not collected, not tested, not sent to the crime lab. Also, remember, because I asked, who would that have been? That'd have been Shaw. I asked Shaw specifically, that tractor and that RTV, what'd y'all do with that Blue Star? And he was like, we hosed it down, the whole thing. Remember, we got a violent crime, a violent murder. The state's trying to say that this was potentially used to transport a 6'5", 300-pound man. Where there is absolutely no DNA based on the Blue Star, and actually their own physical examination of the RTV is actually in the bed of it. Nothing. And also the Blue Star was expired. Now, this just occurred to me just out of other reasons. I just wanted to go because people were just, you never know what a jury's going to think and what other people think. So you just try to cover all your bases. So thought about, maybe they used a winch to get Gary out of the house or something. But there's no evidence of a winch at the house. There's no evidence of a winch on the RTV. Four-wheelers, well, I ain't got a four-wheeler. Got an RTV that's got no evidence on it. No evidence of any ropes, cables, straps, sheets, tarps, horses hauling, dollies hauling. That could either be, I call them hand trucks, or the thing, like 4 square with the 4 wheels kind of dolly thing. No evidence of that. No evidence of any device used to potentially move the body of Gary Farris. Zero. Not one. You got all these photos, hundreds. I don't even know how much evidence we're actually up to in this case. Y'all can count it when you get back to the jury room if you want to. But there's probably 1,000 to 1,200 photographs alone. A lot of them are like this. That's why I put these 3 separate photographs together. It's like, look at all this stuff. But nothing is found. Now the house, I wanted to show you with that because of that. So, we've got none of these things to move the body. And then yet again on the outside, no drag marks at all. All across that ground. Y'all saw the leaves, how the, underneath the tree canopy there, how it is. So you can see that if you were dragging a 300-pound man down that hill, it's fairly steep, that there would be some evidence. And there's not. There's zero. Now Melody's shirt, I just want to show you this. John Luke put this into evidence. And I'm just going to put gloves on to touch it because things get a little nasty when they've been in an evidence bag for 6 years. So, and we didn't do it with the GBI, who actually did the test of the blood. But when you look, because I asked Shaw photographs, y'all have those photographs back. When you look at this, you remember, there's the front of it. Shaw was saying there was blood down here or here. That's where he was saying there was blood. but where there was actual blood found, way up here. He didn't point that out. That's where the GBI actually took the cutting of the shirt and found blood. And whose blood was it? That was Melody's blood. Now, they called the other lady with the GBI, who said that she tried to run what was called a true allele test. And all true allele is just a computer program that can potentially try to separate two different types of DNA. And he couldn't do it. It just said that there was Melody's DNA and there might be the DNA of somebody else of unknown origin and unknown type. So we just don't know what it is. So it didn't work. So you got Melody's blood on her own shirt, and you also got a pair of shoes that John was also put in. There was a single drop of blood on Melody's shoe. And yet again, this is Melody's own shoe. Now, why is that kind of important? For me, it goes to show the quality of the investigation. Because why take those things, send them off to be tested, if you're not going to do the basic thing? Hayes never asked, and we have no evidence of, did Melody wear the red shirt on the 3rd, 4th, or 5th? We know she didn't wear it on the 5th because she's photographed her on the trail cam. So we don't know. No evidence she even had the shirt on. We don't even know. You know, Hayes said he found it in the closet. Remember, we kept asking people where you found the shirt, where you found the shirt. No, it did. He just said I found it in the closet. We don't know. Was it hanging up? Was it in the dirty clothes? Was it laying on the floor? No idea. But again, there's a shoe. Melody's blood. So, just going back to no evidence on the 3rd and 4th that she had those things on. I mean, it's her own clothes, her own blood on it. And there is evidence, remember, because she broke the plate, and that she actually had a cut on her finger. That's in evidence. So there you go. But they didn't take that initiative that you have to when you're investigating somebody for murder. Take the initiative to say, hey, this shirt's got blood on it. When's the last time you wore it? You know, let's document where we found it. Let's take photographs of it before we pick it up. Let's do those simple tasks. But they don't have the initiative. Shoes, who knows? I don't know when the last time she wore one. Put this in. You'll have it back there. I tried to cut and paste using paint. Didn't come out too good. But I just know what it says. These are the blue shoes and the T-shirt saying that is blood of Melody Farris. You know, fine. It's her own clothing. It's her own blood. And her fingers cut. We don't even know when she had them. Also, they sent off some towels, if you recall. Very limited testimony regarding these towels, but they sent off, it looks like 26 was the package, so A, B, C, D, E, F, sent off 6 things, 1 white towel, 5 white washcloths. 2 of those, or all of them, it looks like A and E didn't pass the test. It says 2 presumptive tests for blood did not produce the same result. And the GBI testified that basically they did a preliminary test on it, and they do it twice, and it gave different results. So they said, well, at that point in time, we can't tell you that's blood, so we're not going to test it anymore. The other items that they sent down there were negative for blood. Now the barn. The bane of my existence, that nothing was really done in the barn. Other than Lieutenant Stewart, and you know, I kind of feel bad for him, kind of like I do Hayes sometimes. Is he just got told to go out there, but to his own fault, he didn't take any initiative. And yet again, when you're investigating a murder, you got to have some initiative. Because he took photos, but asked him about Blue Star, all that. He said, "I wasn't asked to do it." And you know, one thing is good. Going back to Lieutenant Stewart, he works in the courthouse now. So I see him every day. And, you know, I was even talking to him this morning. But at the end of the day, it's like, you got to do your job. Whether or not I like you. Lindsay and Allison over there, every day. Talk to them almost every day. See them every day. Most of the deputies in this courthouse. But I tell them the same thing. If you're going to charge my client with murder, then you better take some initiative and actually investigate. So the barn. They took photographs of the barn. That's it. That's literally it. And we had pointed out, and I'll switch the slide in a second, just because we were going through, and I'll kind of lay the framework for this. What we did is our staff, who they got here late, and so they did not get a seat, are standing over there, two of them. Now, they had to go through and print out every photograph in color in this case. One folder that is from July 15th has 2006 photographs. And we had to print, and that's one folder. There's probably almost 3,000 photographs taken in this case in total. So we printed all of those out, and John Luke sat there listening to interviews, flipping through photos. And then I started going through and flipping through photos. And then we started noticing that, Scott living in the barn, and, he's a 30-something-year-old man, probably not going to be very clean. It wasn't too bad, but his living quarters, pretty nasty. Dog feces all on the floor. Not the cleanest. I'm kind of a clean freak, so I pick up on that. But what was curious to me, a 30-something-year-old single man living in his parents' barn, that bathtub and that sink are spotless. And law enforcement took no initiative to say, okay, this is kind of weird. The rest of the house ain't too clean. Why is this absolutely spotless? And also, there's a magic eraser in the bathtub. I mean, at a minimum, go to Blue Star. What if he was washing off blood? But we don't know, because they don't have initiative. Same thing, you'll remember, or you're probably wondering, like, why in the world are they putting these in the photograph? And I don't have it on a slide, but you'll remember downstairs in the barn, I think Mr. Fogus put in some, and I put in some too. There's that drain, and there's a water hose running over to the drain. We actually took close-ups of it. No Blue Star at all in the barn. And they had, they can't use the old, it's expired excuse, because they called Renee out there, and I asked Renee, did they ask you to go out and Blue Star the barn? What'd she say? Somebody asked me to. The bullet. This is just more for my own curiosity why I kept asking these questions. And the answers were kind of shocking. We know the bullet on the right. We know who found that. That's the one from in the basement. That's Kuykendall. He found that. But the one found in the rib in the burn pile, of who found it. Dr. Gooding, remember her, she was the actual anthropologist. She said she found it. Now, before she testified, Detective Westbrook testified. You remember him, kind of the bigger man with the beard that we put in the photographs of Melody's car. He said he found it. Sally Sims, the coroner, who made herself a witness in the case somehow, she said she found it. And then everybody's favorite investigator, Shaw, he claimed he found it. It's just puzzling as to, what is supposedly a critical piece of evidence in this case. And you've got 4 of your own witnesses being the person who claimed to find it. I mean, that is simple. That's really the easiest thing you could have done. Because who saw it first? Documented, located, bullet, rib, done. But they got 4 people saying that they're the one that found it. Just doesn't make any sense. Like a lot of things. This is the GBI, the ballistics report, saying that it was a 38 bullet as found in the basement. And you'll see the way they differentiate it. 38 bullet basement floor, and then 38 bullet jacket. That's the one from the rib. When it says bullet jacket, that is the one from the rib. And that one is in evidence somewhere. I think it's probably in here. So you can actually have that packed in a clear case where you can actually look at it. And you'll also have, and I'll just talk about that while we're here, you'll also have what's called a bullet comparison sheet that Mr. Fogus put into evidence with Ms. Bagwell with GBI. And what that shows is you'll see the comparison of the bullets. A lot of it probably won't make sense. But if you look at it, and from her testimony as well, you'll see that basically from the bullet in the rib, she based a lot of her assumptions off it based on the bullet in the basement. So the bullet in the rib is burned up, and I said, how can you tell what kind of bullet it is? And she said, well, I'm making the assumption that since the bullet in the basement is a Hornady brand, according to her testimony, I'm just making the assumption that the bullet in the rib is a hornady as well. And I would say assumptions isn't reasonable doubt. It certainly isn't beyond reasonable doubt. You'll also see things like the weight of the bullet and stuff like that. They're both very, very different. But y'all will have all that back there to look at. Next, we also learned that 357 Magnum can shoot a 38 special bullet. Pretty well uncontroverted. There's plenty of evidence about it. And there's also, when you're looking at this stuff, you'll see that the GBI, they gave a list of possible firearms from the bullet comparison. And most importantly, it says this list is provided as only an investigative lead and is not intended to be an all-inclusive list. So short answer is, it's a 38 bullet. What kind of gun shot it? We don't know. But it may be some of these or some like these. Now, bullets, these are what Scott had in the barn and in his bedroom. The one on the left is actually from his nightstand. And what kind of bullet are those? Those are 38 special bullets. 38 special, 158 green, lead round nose. American Eagle. And I also heard Scott talking about, actually he said it, Chris said he didn't own a handgun, never did. We know that's not true. But he's got this many 38 bullets in his immediate realm, so to speak. That's a lot of 38 bullets for somebody that doesn't have the ability to shoot a 38 bullet. But he did, because we know from his own testimony, he had a 357 Magnum. Now he claims it was stolen, and we'll get into that in just a few minutes. But, so that's a lot of bullets for somebody that ain't got a gun. Now what did he say? Well, somebody bought those over. Who? No idea. When? No idea. I mean, bullets are fairly expensive. I'm not going over to somebody's house and leaving my box of bullets. Yet again, just doesn't make sense. Missing 357. And I call this, you saw that next slide, the magic gun. We'll get into it, but I want to talk just real quick about Scott's missing 357. So, John Luke had introduced these with Scott, and it was Scott Defense 97 through 100. And you heard John Luke questioning him about where was your gun stolen and all that. He said it was down in Columbus when he lived down there. House got broken into, remember? Guns missing. They called law enforcement. So, all right, we got a stolen gun. You know, your gun gets stolen. You obviously report it because, you know, I don't want my gun being used in a crime coming back on me years later or days later or whatever. So he claims to have reported it. So we asked the Muskogee County Sheriff's Office, give us all records. I believe it was between a certain year time frame regarding the 357 Magnum, other firearms belonging to Scott Walker Farris that were reported stolen. We are requesting copies of any incident reports 911, and we asked for that to be between the years of 2008 and 2015. And Muskogee County Police Department, from the sheriff himself, Scott 98, in response to your open records request submitted to the Muskogee County Sheriff's Office, please be advised that the Sheriff's Office was not able to find information requested in your details you gave. Therefore, there are no documents that exist. So, Columbus is a big town. Had to call my buddy Cody, because he's from Columbus. Actually, I asked him what county it was, because I didn't know. So we found that out from him. Then we went to Columbus County Police Department, sent them the same records request, 2008, 2015. Good day. There are no records in our system for Scott Walker Farris. I did check our jail system as well. No records. He sat on that stand and told you, under oath, that his 357 was stolen. So what is more likely? That his 357 was never stolen, or that two law enforcement agencies lost the records of a stolen gun and a burglary that he claims to have happened. Now, the magic gun. This, I have been on this case longer than anybody. Longer than all. I've outlasted every prosecutor. I don't even know what number I'm up to now. I've been on it longer than John. The only person who has been involved in this case longer than me is Hayes and Miss Farris, and then me. And this has infuriated me from the get-go. And I have waited for 6 years to get to stand here to talk about this gun and this absolute nonsense that the sheriff's office took hook, line, and sinker from that man's mouth on July the 5th. The magic gun in the basement. So what did Scott say this gun looked like? That it looked like that. It was chrome, it was a snub nose, he didn't touch it, he didn't take it out, it was in some kind of a holster, but he could see what it was. Remember, he didn't want to pull it out because DirecTV guy's there. And I would also tell you you'll have back the text messages that Gary tells him to come over, the DirecTV guys coming. Now you can read those and use your own common sense and reason. I can't tell from those text messages because Gary actually tells him, come here, I need to show you something. It's like, SSR, whatever it is. And then they talk about DirecTV guy got pushed back to 2. And it almost seems like in those text messages, he's having Scott come over just to help with something that he's actually there. Not Scott's version where he's having to go over there to let the man in. So you'll have it, you'll read it. It's just a little something to think about. So that's what Scott says is that he finds or he goes to look for. First he finds, tells no one, and then he goes and looking for it on July 5th. So it's in the basement. Now Martha Jane, she's safe for the end. What did she say? Looks something similar. She actually said she couldn't tell what color. She didn't know what color it was. Now Jenna, that was out of the blue, got on that stand and said, August 2024, over 6 years later, here comes Jenna into their office and says, guess what? I saw a gun too. And that's what she told the investigators. And they actually made her, and it's in evidence, you'll have it back there with you. If you'll remember, we actually put it in 3 different photographs of guns and said, pick, what gun did you see? Wanting it to be that, to corroborate Scott and his lies. But nope, they can't hold it together to do something like that. She picks a completely different looking gun, wood handle, black, and that's what she said that she saw. And we'll get to the locations here in a minute. Now, Chris, on the other hand, yet again, 6 years later, he hops up on the stand, and guess what? He's seen a gun too, but he didn't see it in Purcell Lane House. He saw it back in Alpharetta. Remember, it was just laying on the kitchen counter, and he never told anybody, and he took it and he put it up on top of the refrigerator. And what did that gun look like? We don't have a photograph of it, it's not in evidence. But he said it was a silver gun with an ivory handle. Ladies and gentlemen, what I would propose to you, what that is 3 people trying to corroborate one. The problem is they just don't have the capability to hold it together because it's a lie. You know what Mark Twain said, that you don't have to remember anything if you just tell the truth. The problem is when you're lying, you've got to remember the details of what you're saying. So Jenna knew to say it was a revolver. She couldn't remember the color, couldn't remember the handle. Chris, same thing. He remembered the color, but he got the handle wrong. He also got the location wrong. He said he saw it. They moved to Purcell Lane in 2013. So it had to be before 2013. Chris never told law enforcement in all of his interviews, sitting there talking to Hayes and Kuykendall and Pope, never said anything about this gun. Jenna never said a word in over 6 years about seeing a gun in that basement. Martha Jane, yet again, she's got her own slide. 2019 to 2024, 5 years, 2 law enforcement interviews, nothing. And Scott telling law enforcement within minutes of arriving on July 5th. Remember what Chief Deputy Pinion said? He's literally just walking down the driveway to the house to get things checked on, and here comes Scott. And then he said, he changed the conversation and he starts talking about a missing gun and affairs and pointing the blame at his mama. Immediately. And you heard it from Amanda too. Amanda gets there, I'm going to check on that gun. You don't even know what's happening. You don't know where Gary is, supposedly. You don't know that might be a gun involved. You don't know anything. Why are you looking for a gun? Also, why are you these kids? Your dad's missing, and let's go through and let's look for his wallet. Let's look for guns. Let's see, where's his credit cards at? You got Emily days later trying to access bank accounts. Pope had to go out and freeze all the bank accounts. Took all Amanda's money, hadn't done anything. Nobody accusing Amanda of anything. But all her money got frozen too. Remember, because I think she said it was about $800, and that's all she had. Now, yet again, when you're operating under a lie, so you got to remember where things are. Scott said in the left-hand photograph, that's where the gun is. That's where he saw it with the DirecTV. Jenna, knowing it was the basement, but can't keep it in the same place, puts it over there in that thing. I don't know what that is. Armoire, whatever. Basically, it's on a whole nother side of the basement. If you remember, you'll have those photographs. The Scott location's up by the sliding glass doors behind the couch. Jenna's location is over essentially behind the bar. Two different locations. Now, here is my whole point of law enforcement buying this whole magic gun theory from the get-go. Oh, and also, Scott saying it was a snub nose. What does every human being that knows anything about a gun think when you hear snub nose? 38. It's just the first thing that pops in your head. 38 special, all that stuff. That's what people think about. So he was very clear in saying it was a snub nose. He didn't say 38, it was a snub nose, and he gave the color of it. But what has hurt me since 2019 is the fact of this. So, who stores their stolen murder weapon in the living room of the victim? So let's see what they're wanting you to believe, because Ms. Frankish talked about, they're going to meet their burden, and I'm going to send you down rabbit holes and get you not thinking clearly about the evidence. This is their evidence, right? Their evidence is Scott located a gun in the basement. That gun is corroborated by Martha Jane saying that her gun was stolen, right? Because they're similar in the slide I just showed you. They're similar. All right. Now, what intelligent human being, if you're planning to commit a murder, stores your murdering weapon in the living quarters of your victim? That is the most asinine thing I have ever heard. If I'm going to murder someone or shoot someone, I'm going to keep my gun close to me, in my part of the house, in my purse, in my pocket, in my car. I'm not going to store it in my husband, according to them, that she despises, behind the couch that he sits on and watches TV, where Scott claims that he sits and watches TV. What sense does that make? And that's why when you're talking about reasonable doubt, it says in there, in that law, common sense. Because you can't, there's no way that the state can explain that away. What, Mellie's just so stupid she didn't know where to put a gun? If that's what you want to believe? That's ridiculous. This whole magic gun, it is the biggest farce I've ever seen. Botzon, just briefly, he did the CPAP machine, the Dell computer, all that stuff. CPAP machine, he used an open source, which just means free, program to interpret the data that he extracted from the SD card taken out of the CPAP machine. We had asked him, was that program approved by the CPAP manufacturer? No. Did you do any testing to make sure that the data coming out is correct and you can actually prove it that it's correct, verify it, when it comes out the other end? And he said he didn't do that because he had to essentially just dump all of the information into the program, and that's what it spit out on the other end, all the dates and the usage and all of those things. So remember, I asked him, I was like, why don't you just take July the 1st plug it in, see if the data comes out and matches, then you've got it verified that this program's actually doing what you would expect it to do. And he said, well, I can't do that. I have to do it all at one time. So essentially, we have a non-approved or tested open source computer program to translate the raw data from the SD card. So you can't determine the accuracy of the translation. Even Bob couldn't say that it's correct, what he was testifying to. He can just say, here's what this program that's not approved says. Also, the trail camera. Scott admitted to deleting the trail cameras on July 5th during the middle of the search for Mr. Farris. You didn't hear any evidence of Scott telling law enforcement in any of his questioning and interviews or anything like that about deleting the trail camera. You just heard that from the stand while he was testifying. But talk about the trail cameras. So that is 12/12/75/2018. That's Scott. He admitted that's him. Amanda also identified him. That is him walking up to the trail camera. Now, what you may be wondering is, how do we know that that's when the photographs were deleted? Well, we know that because there's essentially a way to print out the photograph to where you can get the data, call it metadata, call it whatever you want, of each of the photographs that were on the SD card. The two relevant ones, you see on the top one, Scott walking up, and it says deleted at the bottom, deleted true. That means that it was in fact deleted. So every photo before Scott is deleted. And then he's picked up on trail camera at 12:16 and it says deleted false. He's walking by covering his face. So he essentially deleted it and then got picked up walking by it 4 minutes later. Now, what was his excuse for that? Well, just searching for my father. I think a gun's missing. I'm worried about his safety. Need to check the trail camera and, I just always delete photographs from the trail camera whenever I go and check it. In the middle of searching for your father. State's evidence. All right, state's experts. Dr. Gooding, Hope, and Adams. Gooding was the anthropologist, Hope was the fire lady, and Atkinson was the medical examiner. So Gooding, remember I told you this would come back up. Best we can tell, or the best she could tell, is that bullet found in the rib is somewhere around those black arrows. And remember she said, and this is important, I think, their own evidence is saying that bullet is front to back, right? Front to back. So, first off, the body got to the crime lab July 7th. Claims of projectiles on the inside of the rib. So, remember as Dr. Arden explained to you, bullet's going. Their expert says that bullet is front to back. That is her expert opinion. Fine. Dr. Arden said, we accept that as fact. If that is a fact, that bullet is here. It is lodged in the soft tissue in between two ribs and did not enter the body. Therefore, that bullet could not cause his death. Claims trajectory is front to back. Dr. Gooding didn't know if the projectile lodged in soft tissue is from the front or the back, but says it's a sternal rib end. And so that's when I asked Dr. Arden about what is sternal rib end, and that is the ribs that are connected to the sternum coming off at the end of the rib. In the front, remember, if you remember from his testimony, I was able to show him with the little hand on the PDF. Yet again, Gooding couldn't tell, and none of them could tell me about any vital organs. And what Dr. Arden said is you can't say it hit any vital organs, and that bullet, if it went front to back and it's right here, didn't go into his body. Also, most importantly, Dr. Gooding found no damage to any bones by projectile or otherwise. So there is no evidence, according to the bone, really, or the soft tissue. There's no evidence of saw marks, cut marks, knife marks. No evidence to the rib where the bullet is found, lodged in between the two of them. It had not been damaged. And there's no other damage to any other bone other than thermal damage caused by the heat of the fire. So looking at it from the state's case, they want to say that Gary Farris was shot 2 or more times. Right? If that is the case, he shot 2 or more times and not a single bone in his body that that they can find was damaged. Now, this is Dr. Pope. That's just a little snippet of her report, because I just wanted to read basically her findings to you. She said that that's easier if I just read it. The fire that burned this victim's body is consistent with a single burn event where the fire was set and left to burn as a slow rendering fire. And then for some reason it says in parentheses hours. That remained undisturbed until discovered as a crime scene on July the 5th. The duration of the fire was less than 24 hours old. You'll remember from her testimony, she made that assumption based upon how hot the fire was when law enforcement arrived on July 5th, somewhere around 1 o'clock or so, 1 o'clock, 2 o'clock, whatever that is. Now, the important thing is that 24 hours. I also wanted to point out, so it's post-testimony that Gary's remains are in that state of cremation, being on the burn pile 24 hours or less. Okay. You remember from those interviews you were hearing where Kuykendall and Hayes are talking to Melody, saying that we've seen people come out of house fires. We've seen people die in collapsed house fires, and they don't look that bad. They're not burned up like that. According to the sheriff's office, they don't even believe their own expert, because she said it happened in less than 24 hours. And not a house fire, an open pit just laying there burning. And also, no accelerants, no gas, no alcohol, no nothing. Now, the reason that 24 hours I've always thought was curious. So if the fire was 24 hours old, 24 hours old when they arrived on July 5th, 1, 2 o'clock, that means that the fire had to be set less than 24 hours or less before. So that'd been 1 or 2 o'clock on July 4th. Common math. Actually went over that with Pope, and she agreed. Because I think, actually I do remember, I was crossing here and it was 1:09, if you'll recall. I was like, it is 1:09 p.m. right now, 24 hours ago. It was the day before at 1:09 p.m. and she said yes. So 1 or 2 o'clock, law enforcement's there. Fires burning less than 24 hours old. Well, at 1:54, Melody is an hour away on the 4th of July, verified at Lake Lanier. So we know that it's about an hour or more on a major holiday to Lake Lanier. Amanda said traffic was horrible. Getting in was horrible. Also know Melody went to Target, had to go buy the chair. We don't know exactly when she left, but through the state's expert, it seems like less than 24 hours, unless you just want to say, well, less than 24, maybe it was 10, maybe it was 5, whatever. Use your common sense there. But if you put it around the time of 24 hours when that fire was started, according to their expert, Melody's in Lake Lanier. She wasn't even on the property. And that is verified by that receipt. That is verified by Amanda. That is verified by Cameron as well. That Melody wasn't at Purcell Lane, that she was at Lake Lanier. Now, Dr. Atkinson's report, you'll see, this is basically the summary of the findings that Dr. Arden was referring to. I probably should have put it up when I had it. But it says basically you can't find entrance wound and unable to assess direction of a wound path. And like Dr. Arden said, a wound path is a bullet going through bone and muscle and tissue and subcutaneous fat, being able to track the path. Now, Atkinson was the whole copy and pasting. I'll get to that just a second. But he couldn't say what organs were damaged again. Remember, I asked him, did he die of blood loss? Did he, was his heart hit, lungs, liver, all of that? He says he don't know. They want to blame everything on the fire. Dr. Atkinson couldn't say to a medical certainty that Mr. Farris was alive when he was shot. He did not want to answer that question. And if you recall from his testimony, he started giving him this big, long spiel about how I was like, no, you answer my question. Can you say to a medical certainty he was alive when that bullet entered his body? And he said no. And that corroborates what Dr. Arden is saying. Dr. Arden, complete honesty, was like, I'm not saying that you can't say that this is a homicide, but I'm just saying being academically honest with, I think his word, is I can't say that it is or is not. And when you've got is or is not, then you've got undetermined. And when you can't tell me to a medical certainty a man is alive when a bullet entered his body, then how can you say honestly to a medical certainty that a bullet killed him? And you can't. Dr. Atkinson couldn't say what rib the projectile was lodged in. He actually knew less about the rib and the bone than Gooding did. And the reason why is because he just copied, and he admitted to it, he copied Gooding's findings directly from cut and paste, directly from his report, her report, into his report. He never went out to that scene. He's putting things in this man's autopsy, talking about it was found on a burn pile, and here's what we did, and all of these things, saying that these things are factually true. But he didn't go there. He didn't do any of those things. He's basically taken somebody else's work, hadn't proven that he's actually, verified it other than just who she is, and just said, this is true and correct. I'm going to say it's a homicide. Dr. Ard, I've talked about it so much. Remember, he just said, look, I think actually what he said was, I'm not going to say it's crazy, to say that y'all have listed this as a homicide. I'm just saying, y'all haven't showed me, excuse me, y'all haven't showed me, and he had everything, all the, he went over all the reports and everything. Y'all haven't showed me to where I can agree with you to a medical certainty. I'm not going out there. I'm not putting myself out on that limb. Dr. Atkinson, he wants to put himself out there on that limb, be my guest. But Dr. Arden was not willing to do that. And you heard, I think you said, 3,000 autopsies that he had performed, been a medical examiner for 40 years, still practicing, got his own consulting business, all of these things. He's got all the credentials, in the world. And he's saying, no, I'm not going to go out on that limb based on these facts. And that in and of itself is reasonable doubt. Other witnesses. Ms. Frankish wanted to talk a lot about Addison and the text message to Melody, because that means that on July 3rd, Melody was planning on killing Gary. There's absolutely zero evidence of that. There's no text message, phone call, search histories, where there was any planning or preparation on July the 3rd. In fact, you'll recall Addison and Chris come out to the house. They come out to the house on the 3rd. She had just landed. Addison actually says they left. And then sometime later, she texted Melody. And Melody didn't say, no, you can't spend the night. She said, how about tomorrow? And in fact, she did spend the night the next day with Cameron. But also with Addison, and the whole reason I called Cameron, y'all are probably like, this kid don't know nothing. But she did prove one thing. Addison, who is Chris's daughter, who was interviewed a year later, who testified that she's only hadn't had any contact with Melody, but had contact with Chris essentially through her mother, because that's how she had learned about the death and all of those things. But she made it seem like when they got out to Melody's house that Melody was not wanting them to go outside, didn't let them go outside, making them go get a bath way too early. You saw the text messages. It's 8:30 when she tells them to take a bath. They sneak out of the house, go get in the hot tub. Now, what's important, what Cameron actually establishes is Melody wasn't acting weird. Melody wasn't restricting them to go outside. That they went up to the barn, they went and looked at the horses, they went and saw the animals, they looked for Gary, and both of them confirmed they were down in that basement, and they didn't see any blood or any bullet. Nobody did. Nobody did on the 4th or the 5th. Anybody that was in and out of that house. Oddly enough, the last person, best you can tell, is the last person to come out of that basement is Scott, before law enforcement gets there, looking for his magic gun that nobody's ever found and that nobody's seen. He's the last person to come out of that basement. And then the bullet is found. Chief Deputy Pinion, we've already talked about him. Him and Scott, he's just trying to see what's going on, and he's got Scott in minutes throwing Melody under the bus. John Lambert, that was really just to show the weird dichotomy, because Scott and Chris and Emily wanted to get on the stand, or did get on the stand, and basically say, oh, Daddy dearest, I loved him so much, I miss him, I can't believe this. While at the same time, you got Chris robbing him blind, him actually saying he was stealing, him admitting that he had used his bank accounts because he had the account numbers and all that, which is illegal, and he was doing it without Gary's permission. Gary actually texted him and said, "Your stealing has got to stop." Scott texted Melody saying, "Is he gone?" Wanting to know if Gary was gone so he didn't have to do anything anymore. Those aren't the text messages of somebody who, you truly love this man. No, that was just their bank. And he was getting ready to cut them off. So Lambert, that weird interaction, he said, it wasn't fisticuffs like Mr. Focus likes to say. It didn't rise to that level, but he said it was just weird. And then Scott making the statement, "Can't wait till you're gone so I can get this," or something to that effect. That's weird. That's not the statement of somebody if you love your father. Dave Thomas, yet again, showing Scott's aggression. With a whole, Miss Frankish, she got up here in her opening and was saying, well, Scott's dad was dead and he had a right to be upset. And then she said, his trailer. That ain't his trailer. That's not his property. That is Melody and Gary's. He wants it to be his, but it's not. Just like they want the money, they wanted the house, but it's gone. They wanted everything. They acted like it was theirs, but it wasn't. And Miss Frankish bought right into it, came up here and told y'all exactly that. He's upset his dad died. He's got strangers using his trailer. It ain't his. The owner of the trailer was standing next to it with Dave Thomas when he comes up acting like a nut, then chases him halfway over to Versace. Martha Jane. She's known about this case since July the 5th, 2018. July the 5th, 2018. In the middle of this trial, she called law enforcement and said that, "I have to tell y'all something. Melody stole a gun from me in 2019, and it was a .38. And when did she say that? After, and you'll have this back there with you, after she admitted to it, after he watched this man on YouTube commenting over Rusty's testimony. And the title of this video, "Did I Just Crack the Case?" Because that man said, and I asked her, that's where the gun came from. The next day, she is on the phone with Captain Hands telling the story about how Melody stole her .38. There is no evidence that she ever owned a .38. They got some .38 bullets, but also just to show you, those are Winchester, not pointed A. The .357 that her husband owned was still there, and it also shoots .38. So it makes sense that you could also have .38s. But there's no receipt. There's not a photograph of this gun. There's her words 6 years later saying that she's got a gun. Now, she sat on the stand and said, well, law enforcement never asked me about no guns. Yet again, July the 5th or the 6th, she knew Gary had been shot. And you don't think that might be relevant then? It only becomes relevant when a little man with a YouTube channel tells you that it's relevant. And she admitted to that. She also admitted that she was embarrassed. She was furious at this affair that she found out about, essentially on live television. Now everybody in Tullahoma knows it. She said she got to hang her head whenever she goes. Rusty destroyed the Barton name. And I also asked her, you believe that a mother should always protect her children? She said, I do. And I said, when you saw John Luke and I crossing those witnesses, you were furious. And that's when Mr. Fogus started his objections about let her finish her answer. Let her answer. She's 85 years old. She might be 84 years old. She might be 84 years old, but she came up with this lie because of YouTube and this trial being on television. That's the only way that she came up with this. She wants to talk about, Miss Frankis wants to talk about her picture is in the dictionary next to the word credibility. She has no credibility. She watched this whole trial. She knows everything. She knew to even say what color the gun was because she can go back and watch Scott's testimony. What did she do? Yet again, can't get the color right. She got the holster kind of right. She can't get the whole thing because you got to remember stuff when you're telling lies, and it's hard. And I'm sorry, when you want to show up in the middle of a murder trial 6 years later, 5 years after you discovered a gun being gone, and your excuse is nobody asked me, and it doesn't become important until 2-3 weeks in, that's the definition of no credibility. And especially when you can't even prove to me that she owned a gun. And, you know, she's got an excuse for that too. Didn't like guns, she moved it all over the house, blah, blah, blah. Show me something. They got nothing. I'll go on for more, but I gotta hurry. How long have I gone? Real quick, motive means opportunity. Motive, they want to say it's money, all right? Melody had access to money, seen the house, she could buy whatever she wanted. Here's where they messed up though. It was with the financial accounts. You'll look at those. You should have them back there with you. Gary had actually added Melody back on as a life insurance beneficiary in 2012. That's around the whole Ted Wiley fiasco and her leaving Alabama and all that. Got in the back. Here's where they messed up. They did not prove that Melody knew anything about the existence of life insurance. There's not a single witness who has said Melody knew about the life insurance policy, that Melody knew that she was a beneficiary. In fact, you heard from their own witness, Martha Jane. She said Melody didn't know anything about their finances. She didn't know where the money was. She knew that she had a debit card and that she could use it, and a credit card and that she could use it, and that Gary tracked her. But she didn't know anything about other than that. She didn't know anything about the life insurance. She didn't know anything about the 401k. She didn't know about the partnership stuff though, because she called and asked about it. But that's it. They want to say that money is the motive, then you might want to establish some evidence that the person who's wanting the money even knows the money exists. The only thing that Melody knows about money existing in this trial that is a proven fact is a receipt in her car with $11,000 in the bank account. So with that, I'm going to just go ahead in there so John Luke can do his part, but that's the confirmation bias. And that's what it looks like. You remember I talked to you about that in the opening. Confirmation bias. They got their beliefs and they leave all these facts. So with that, ladies and gentlemen, I would ask you to find Melody Farris not guilty of all these charges. Mr. Weavers, after a break, we'll be talking to you next.
All right, let's take, try to keep it 5 minutes. Weaver, go ahead.
Mr. Frankish, Mr. Fogus. Ladies and gentlemen of the jury, we're already halfway through a long day, and I'm going to try to be as quick as I can. You've heard my partner, Mr. Ray, speak about a lot of facts in this case, but I want to speak to you now about the gravity of the situation. What we're here and what we're asking you to do and why we're asking you to do it. You are a jury, and you're well aware of that. And I think Michael mentioned my books, and this is a book I got on my first day of law school. It's the Constitution of the United States of America. And there's an amendment, the Sixth Amendment to the Constitution, and it's been in place since 1789. And it is the Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. I think we've given them a public trial. By an impartial jury of the state and district where the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and the cause of the accusation, to be confronted with the witnesses against him, back then it would have been him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. That's it. That is the bedrock of what we're doing. And it has been here for a very, very long time. I told you back in jury selection that I was only looking for my client 12 fair, impartial jurors honestly seeking the truth. And you all swore that that was you. And you have sat here very diligently, and you have paid attention and taken notes. And we've all noticed the effort and time that you've put into this. You have put in weeks of your life. You have missed time from your families, your jobs, to be here for this very, very heavy, important moment. And I also told you you had another job. And I don't have my PowerPoints. I go with literally what you guys are going to have to work with. This is the charge that the judge is going to read to you once Ms. Frankish is finished speaking in this case. And your one job was to hold the state, and that's my job too, is to hold the state to their burden of proof. What is it? I'm just very clearly and succinctly going to read it to you, and then we'll talk about it. And I'm going to talk about some other elements of doubt that I think we should discuss, and I'm going to sit down, and the defense of this case will be over. We're going to leave this to you, the jury, who is the most important group of people here. And I want to know, and I want to know this. I've been meaning to tell you this for weeks, and I can't tell you this. My client, you may notice that she does everybody else in the courtroom. They rise for you. They rise for the jury. We don't. Here's why. You are a jury of her peers. You're her peers. We're on the equal footing. The judge sits above us all as he represents the law, and we are all under the law. So when the judge walks in, the bailiff says, all rise, we rise for the judge as the representative of the law that we must live under. But our framers, who wrote this Constitution, and then, I had to go dig this up. We don't actually use these books much at the office, I'll admit that. The Constitution of the state of Georgia, which was actually adopted in 1983, so it's a much newer document. And it embodies the same principles in our modern time. Now, some may say 1983 was quite a long time ago, but not to me. It embodies it in our real time, in our real life to this day. Because our framers knew the government is, in fact, that's why we're here. That's why we're not part of Great Britain anymore. And almost every, even the modern democracies of Western Europe kind of think we're nuts. They think we're crazy. Because we have 12 people who have no association with the government is to come in here and decide the facts of a criminal matter, to check the government. For that very reason, we left over there because we knew that the government should always be checked, not just trusted implicitly with power. So I just wanted to explain to you, my client is not being disrespectful. I told her to do that because I so believe that we are equals. We are peers. The burden of proof. The defendant, and still is, by the way, presumed innocent. This case is not over. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of this case with the presumption of innocence in his or her favor. The presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt the defendant is guilty of the offense charged. 4 offenses in this case. No person shall be convicted of any crime unless and until each element of each crime is proven beyond a reasonable doubt. You're going to get this document. This is the indictment. These are the charges. They have to every page of this indictment. Count 1, count 2, count 3, count 5. Every element, every word has to be proven in each count beyond a reasonable doubt. It can't just be maybe. I'm going to slow down. No person shall be convicted of any crime unless or until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever. And the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. So here it is. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given arising from the consideration of the evidence, a lack of evidence, or a conflict of the evidence. After giving consideration to all the facts and circumstances of this case, if your minds are wavering, unsettled, unsatisfied, then that is a doubt of the law. And you must acquit the defendant. It says the word must. But if that doubt does not exist, if your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it is your duty to acquit the defendant. You will be given this. You'll be given a verdict form with 5 counts. Count 1, malice murder. Count 2, felony murder. Count 3, aggravated assault. Count 4, concealing the death of another. And count 5, making a false statement. It is, in fact, a heavy burden. But I contend to you that the state has not come close. Mr. Ray is far more eloquent than me. Mr. Ray is smart, far more intelligent than me, and his brain works in a way I truly am fortunate to have such a good partner. But he found that diagram years ago of the stairs. I've always used, I'll come down here and I use the bar. I say, a scintilla of evidence is down here. Probable cause or preponderance of the evidence is somewhere towards the middle of the bar. Clear and convincing evidence, which is not the standard in this case, is a little further up here. And then beyond a reasonable doubt is almost all the way here at the end of the bar. It's not all the way. I'm not saying it is. But I think this case that we have sat and listened to, and I think the time was taken as needed to get through the case. For you to see every bit and every element of this case. But here's what I think you have clearly seen. And this is the first doubt that I propose to you. That the district attorney's office and the sheriff's office and all law enforcement involved in this case from day one, from the early minutes of the 911 call, which let's think who made the 911 call. It was that man right there. He was in control from the very first minute of this case, Scott Farris. Scott Farris was always in control. And the fact that he had to immediately control the case, to me shows doubt. And I do believe it is a heavy doubt. When you look at everyone involved, every witness that you've heard testify, and that's another thing you need to know. You need to know that's your job, and you'll be charged on this as well. As a witness, you are to determine the credibility of the witness. Now, I'm going to read the charge. There's not a lot to this charge, and there's a reason why. The jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. What does that mean? Here's what that means. Here's what I propose to you. From the day we're born, in the early years of our life, we begin to get a feeling when we hear people talk. Because the words coming out of our mouth sometimes aren't true. For example, if I were to have a bag, and say I told you that this bag was full instead of shoes, it was full of $1 million. Well, I'm going to take this half of this $1 million and give you guys the other half, and we're just going to leave. But here's what you know immediately. You know that if I had $1 million in this bag, I wouldn't be standing here talking to y'all. You know that. You have that feeling in your gut. Because you know, you've sat here and watched this case, it's a bag full of shoes. It's a bag full of shoes that has no important evidence on it whatsoever, other than the fact that I think Melanie Farris cut her finger at some point and got blood on her shoes. I think they've established that. And I think, and Mr. Ray did a very eloquent job, and I can go on, and I'm not going to, because this case has got to come to an end. But when you think about law enforcement in this case, and their response immediately, let's go back to July the 5th. Let's go back to the time that Scott Farris, who's sitting right there, goes up to Detective Kuykendall, who's sitting right there, and he gets in his car for an hour and begins to tell him the story of the missing gun and his mother's affairs. And in opening statements, Mr. Fogus talked about circles. Circles getting big, smaller, smaller, smaller. And I think circles will be talked about too when we talk about Miss Harris. But those circles were controlled by one man. And that's Scott Farris. The investigation of this case became one-sided in that first afternoon. And I would contend to you, everything that happened, and it's unfortunate for us in Cherokee County, for the jury, for Ms. Farris especially, that it was stuck that way. There was never any true regard or respect for the evidence that should have been gathered in this case. You saw it. You had 1, 2, 3. 3 locations on this massive property. You've been there, you've seen it, that were not checked. All of the countless problems that Mr. Ray unfortunately had to kind of wrap it up because we have time limitations on how we've been up here for weeks. We can't continue on. That's your job. You as a jury are allowed to go back to deliberate, and you get to go through every bit of this. And there's going to be some of you that believe this, and there's going to be some of you that believe that. And the judge will tell you that you are allowed to hold on to those beliefs and stand up for those beliefs. It is that standard that gives you the true check on our government. You are the democracy. You are it. We're having an election in a week. Nobody's got to go vote. There is no draft anymore. Some people don't have to pay taxes. But the one thing you got to do, and y'all know it better than anybody, is when you are compelled into jury service, you have to come. We literally saw an individual brought in here during this trial who tried to get out of jury duty. You've seen it. This is the last duty we have because it's that important. You can take any fact that we may have talked about or even things we didn't talk about, and you argue about it back there. I'm not saying screaming and yelling, but if you got a belief, you state it, and you listen to other jurors, and you make sure they listen to you. It's truly that important. But I would contend to you that the fact that Thrasher, who came out of the crime scene, I believe she testified something to the fact that this was essentially the first crime scene she'd ever been on. She totally and completely failed in intaking the crime scene in the house. And that complete failure of that investigation alone, I think that's a doubt. I think going further into that day and the fact that this investigation was completely veered in one direction, and that's to Melody Walker Farris. So much was left, and that's part of what you've seen in this case. We've been attempting to investigate this case because we ultimately feel that it wasn't. We believe that the complete ignoring of the barn is absolutely, it's just despicable, for lack of a better word. And because they never even looked over there, they never even used Blue Star or Luminol or intook any of those things, even though there were some clear signs that they maybe should have. Gary Farris's card was over there. Scott Farris's bathtub was perfectly clean. They're there. I mean, Michael Ray told you. He told you. We had all those boxes that sit back there, and y'all, I'm very analog. That's the way I am. So we had all these pictures, and I'm going through all these pictures for months and months and listening to all these interviews, and you guys have gone through most of those things. And sure, I got real frustrated one day. Michael's told the story, but I'm going to tell the story to you too. I think you need to know. So after going through this for weeks, preparing for this trial, hours on hours on hours, hundreds and hundreds of hours preparing for this case, I finally threw up my hands. I mean, my paralegal will tell you. Sometimes I throw up my hands and I'm out. Michael says, "Where's John Lee?" I don't know. So I have to go pick up my family's prescriptions at our local drugstore. I go over to the drugstore. And there is this little, she's young. I think she's 17 years old. She loves to read. But I walk in and they're redecorating the drugstore. This is a drugstore that's been owned by one family in our hometown for about 70 years, Jasper Drugstore. So I go in there, get my prescriptions, and she's like, "John, what's wrong?" So I tell her, oh my goodness. And she looks at me. 17 years old, redheaded too, unrelated. 17 years old, she looks at me and she says, "You know, Mr. Weaver, sometimes the greatest questions, they go unanswered." I mean, literally. Ton of breaths. The second she said that to me, it finally cleared it up. Because I've been running around trying to solve this case for 4.5 years. That's how long I've been on it. Mr. Ray was on it longer than me. But because it is not answered, that's a doubt itself. I want to talk about a lot of the evidence that has been shown about phone calls and sexual relationships with Rusty Barton and the grotesque amount of time that was spent by the district attorney's office proving a point that was proven very quickly. And that's that my client had extramarital affairs. But also evidence was shown that so did Gary. And they were in an open relationship. They lived on separate parts of the house. And Amanda, I thought Amanda was a truly fascinating witness. And it's kind of sad that we had to call her. I think she's the only child that is impartial. She literally just looked at you guys and said, "This is y'all job. I believe in my mama unless or until she's proven guilty beyond a reasonable doubt." And I think Amanda is such a credible witness because she also testified she was with her mama the day of the 4th. Nothing was out of place. And sure, they were texting and they were calling. And you see all this back and forth bickering all the time between them. And that's the Farris wheel, the moniker that has come to be in this case. And I know we are all sitting on top of the Farris wheel, and we just can't wait for that ride to let us all off. That's y'all's job. And we're going to get there. But all of the drama and all of the infighting between the siblings and the affairs and the relationships that have gone on. I mean, the affairs started in the mid-2000s. You got Angela Phillips back in the 90s, who may or may not remember if she had sexual intercourse with Gary. All of that insanity. That's their life. But it's not motive for murder. And that is what they have put and leaned so much of y'all's time into. Because they don't want you looking at this. They don't want you looking at what they didn't do to get to their burden. But let's go back to those phone calls the night before. Let's go back to the timeline. There's something that is absolutely bizarre to me. We did not find out until, I think it was last Friday, when Commander Harris testified. Gary Farris went to dinner, we think, by himself the night he was murdered. We don't know. We'll never know. He was at least alive until 9:30 something. When we see the dot moving, if the science is true. But sure enough, he went to dinner. They never thought to go get a video of that. Let's go up there, interview somebody. Maybe he was with somebody at dinner. We'll never know. And I'm not saying that breaks open the case. But But I contend to you, that huge glaring hole in the timeline right there, I'd say that's a doubt. Scott had been out at the lake all day. Golfing, laking. And there was a lot of testimony heard about that and the life and the dynamic that he had on the farm. He referred to the farm as his. He referred to the farm as his property, it was his possession. I mean, his sister even called it kind of comical. But you saw, and you'll get to go back through any of those you want to go back through and see the communications between Scott and his father. What really was happening was that Scott was a grown man who had every second. So whatever they're saying about Melody has to at least apply to Scott. He was completely controlled by his father financially. Bring me back that credit card. Where's my credit card? It better be in my wallet when I get back. Over and over and over. It's in the messages. You've seen it. You can go see it again. So that financial motive alone and that control, wanting something that's not his, I think that's a doubt. The timeline of the phone calls. You will have seen from Commander Harris something regarding activity in phone calls. But I think that you guys have enough common sense to know, and this is just some things we saw, that other days and other times you went back and extrapolated out over a year, sometime back in 2017, and we clearly saw that there was more activity the night before a baby shower in Nashville than would be alleged for Melody to have shot, killed, moved, and burned Gary Farris. This is no easy task. That's a doubt. All of the weapons that could have been used in this case, all of the bullets, the means, the ability, they started talking about those circles. They started zooming in on one person. And it's not Melody Farris. It's Scott Farris. He's sitting here today. All of it. But I think it starts to become clear why I'm doing this. Why am I dropping these bags? These bags are 40 pounds a piece. I've got a few more bags to go. But I want you to know that it starts to become very impossible when you add this up, that someone who weighs 120 pounds can move this. is a doubt in its own right. But there was a person on the property who could. And that's Scott Farris. He's sitting there today. Adrian, if you could come assist me. Both of them, please. No. This is 320 pounds. I am 185 pounds. And that's all I have. I think it is the heaviest doubt of all that they have provided you with no means, plan that this could have ever happened by Melanie. They have established there was tractors on the property and RTVs, but as my client, or as my partner very clearly laid out to you, I'm sorry. As my partner very clearly laid out to you, they didn't do their job. They've provided no way that she could have done this. They didn't check the boxes. They didn't fill any holes of doubt. The state of Georgia has put my client under grave suspicion. That is exactly what they have done. They have put on her grave suspicion, the most grave suspicion of all, and that is murder. But the doubt, I contend to you, absolutely exists. I'm sorry I had to do this demonstration, but they didn't. They didn't show you what 300 pounds truly feels like. I'm not saying I'm the strongest person in the world, but that is as heavy as a thing as a person can move. And I'm almost a 200-pound man. No explanation has been given. And I keep bringing this back because the grave suspicion that they put on her, these affairs, calling Rusty, all of these things. And I want to note about Rusty as well. Let's note a few things. And I know you've listened to it and you saw it. Pope, he threatened to arrest him. He threatened his own warrants against him, the death penalty. Bugged my client for over a year No confessions. Her own daughter has lived with her for years and years and years. No confessions. Now, I want you to know this too, and it's a charge that the judge will give you. My client does not have to testify. She didn't. She chose not to testify. And we talked about this in jury selection, that you wouldn't hold it against her, but the law is clear. The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. However, the defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. Because again, the burden never shifts to us in the defense. I feel like there's been so much time that we felt like we're trying. I'm trying to get you to see the side of the story that was never investigated. I feel like we've been able to do that, but we didn't have to do that. This decision in this case is everything for Melody. Melody has had to live under this grave suspicion for 6 years. But now is the time. 12 fair and impartial jurors, a jury of her peers, can finally give us answers. I'm not saying that you guys can ever answer what happened that night. The greatest questions, I do believe, they really do go unanswered. And in this case, it may be some of you as it was me that day. Very frustrating. You want to figure out what happened. But it's okay to know that you can't. And I contend to you, ladies and gentlemen of the jury, that because you can't explain what happened that night, they have not proven this case beyond a reasonable doubt. And I ask you to please hold to your oath and find my client, Melody Walker Farris, not guilty. Thank you for your time.
All right, we're gonna break for about 30 minutes. We may go, I haven't gotten word that food is here yet, but I directed them to have it here at 12:15. And so I may be closest to being on time that I have been for the last 4 weeks. So anyway, when food gets here, we're going to give you all a break. I'd like to be up and running in 30 minutes. If y'all still need some more time, y'all just let the bailiffs know, but we'll be up and running at least by 1 o'clock. All right, everyone can be excused. We're going to close the courtroom for the recess so the deputies can have a break. So we'll open the courtroom back up at 10 till, and then we'll see if the jury's ready.
The lady in the white shirt right here is Gary Farris's sister. I just broke to. Yeah, she's about to find out what's going to happen. She can see the jury. She's about to find out. Man, has she aged. Woo, 10 years in a week. They always insinuate that, Paula. Whew. I had a great interview with Dr. Isaac Mantilla. I have to leave again today around 3 to go interview someone running for judge. So I'll leave again and come back after that. So what did you all think? What you think? How much does a baby grand piano weigh? How much does a baby grand piano weigh? 500 to 700 pounds. A baby grand piano weighs 500 to 700 pounds. Not having her hand over her mouth, better attorney told her about that. Yeah, they have to watch these things. Or they don't. They probably have people watch them. You think guilty? Did you vote? I have the poll still going. I have the poll. Poll is up. I could drag anything when I set my mind to it. So I have a bit of a temper. And when I was pregnant with my first child, I was unwed and a bit emotional. And we had a bed. It was a water bed back in the day. This is 1988. We had a water bed and we had just bought it and I loved it. It was great for somebody who was fat and pregnant. And the bed, it was whatever wood was at the footboard and the headboard started splitting. I mean, like big splits in the wood. And it was in Mechanicsburg, Pennsylvania. And we took the bed back and they were like, nothing's wrong with it, except for the big gaps, dude. Like the bed is splitting. And the guy didn't want to do anything about it. So me pregnant, smaller than I am today. Like I was like 210 at my max. He didn't. I picked that damn bed up and threw it right into the gravel. Like I was pissed. And they gave us the money back. I was like, they gave us the money back for the bed. I just wanted a credit for a different bed. Like I wasn't asking for too much. But to tell me because I was pregnant, it wasn't splitting, like it was clearly splitting, dude. But anyway, so when you're pissed and you have adrenaline, you can do amazing things. You had to get rid of your water bed. My wife and I just kept drifting apart. Bump, cute. Why does this guy keep slamming shit on the floor? Brenda Folk, I don't know. Were you pregnant with Ollie Mae? I was. I was pregnant with Ollie Mae. And I was very upset. And I was only 21 years old. And you weren't going to tell me what I knew to my face was a split bed. It was just. And my first ex-husband was super docile. It was like this. Hey, Spray, we got something to do here. I should have known then. Since Melody and her attorneys were so sure that it was Scott who did it, plus Chris, it would have helped for her to speak directly to the jurors, right? She couldn't. But we can't hold it against her. Did I ever go to Hershey Park? Yes, I did. I lived about 10 miles from Hershey Park growing up. And my sister worked for Milton Hershey School. She was a house parent for the school. And the school actually owns the park. And because when Milton Hershey died and his wife, Catherine, they left everything to the students and a trust was developed. And basically everything that you see is living off the interest of that trust. It was so well managed. Yeah. And for Christmas, I buy my granddaughters passes to Hershey Park so they can go throughout the year. Hey, good morning or good afternoon now, Murder. How are you? Lori Keith says, sure hope they remember that no one said she picked up 300 pounds. It's not like she cradled him. We can all scoot it when we need to. Dragging is a thing. I didn't know this was happening. Did I miss it all? Sad face. Closing arguments. I mean, the state's going back to rebut after lunch. Will our fellow courtroom patty cakes be talking with us? Let me see if they can. Let me see. You text her. Hey, after you've eaten, do you want to come on and talk? Are you okay? Yep. He's on the burn pile. Did she run in and just catch Scott? I mean, how else would she have known? Means, motive, and opportunity. She didn't run in and say, hey, I found Scott stoking dad on the burn pile. Murder, you haven't missed anything except for the defense. We're on lunch break for 30 minutes. Then we come back. Oh, it's only 30. Cool. Oh, you've been to Hershey Park. It is fun. Now I haven't been in years. Because usually when I go up, it's too hot or too cold. Tammy, she didn't have to lift Gary. Never had to. Farm girl knows how to move 320 pounds. Exactly. Joe Jordan, how about a used waterbed? When I was in high school, that just had a painted wood frame. So I stripped the paint and put padded foam and upholstery over the top of it, and it turned out fabulous. Susan, when she went to Hershey Park, you were still a flint in your dad's eyes. So you went when it was tickets instead of passes, paper ride like the old days. Lori Smith, welcome back. If you want to come on, you don't have to show your face, Lori. I can send you a link if you want to come on and chat. Supposedly, she's 5'4" due to her booking report. Lori, do we have intel on how the jurors took the defense's closing? Flint. I thought I was going to have to pull Flint out of my dad's eye. Melody looks smaller now. She was very fit in those videos. Jail calls. I agree, but I thought she was guilty day one. So Lori Smith spoke with sister-in-law and told her I've been praying for her. She was extremely grateful. Very nice. Very nice of you, Lori. Murder had to work. Murder by Maestro had to work. Paula, the Pennsylvania main line runs through Hershey, and I stayed in an inn there where all night it felt like trains were running over me. Trains are still a big deal in PA. Jebby, I lived in Connecticut for 38 years and used to drive to West Virginia to visit family at least once a year. I-81 has to be the worst road in the U.S. It absolutely petrifies me to drive 81. It's really bad. Cynthia Doolittle, being in a hurry and perhaps ever afraid someone who would see what she was doing, her adrenaline would have been high too. Frenchie's saying, Lori, was she crying? Anyone else there besides you? Yes. Wesley is there and Beach Bum is there. Thumper went to high school in Lancaster with the kids from the Reese family who sold Reese's. Okay, so small world. So I sold a house to one of the daughters of the Reese family here in Tallahassee. That's how small of a world it is. She is hiding. I can see less of her head than Monday. Does she still look like she's in the aisle seat? Yeah, she does. Lori says, no, she wasn't crying in regards to the sister-in-law, but the brother shook his head. Oh, that's the sister-in-law that was there. When one of the fertilizer bags was dropped, it was really loud. Being so close, yes. So back in the day, before they moved their chocolate operations to Mexico, you would drive down the street and smell chocolate. They still make peanuts, the peanut butter Reese's. The Reese factory is still open, and they still make them there. But Milton Hershey did it right. I mean, first of all, he stole the idea from Wilbur Chocolate. That's the first thing. Second thing is he had the farms. And the students, his children, ran the farm. So all the dairy milk, everything came from the farm, and they just brought in the cacao from South America. They still have the Hershey Kiss lights out, which are, 70, 80 years old now. Michelle says he was already close to the burn pit. So the defense made its closing argument. 2 of the jurors were nodding their head. We'll have to see how many Madam Prosecutor closes her argument out. Beach Bum says she literally jumped when the bags dropped. I'm going to have to rewind it later too, Murder. I wasn't here. I had a meeting. Wesley says he's there in the courtroom. It's not enough time for him to go home because it's only 30 minutes. Carolyn A., I move furniture on my hardwood floors and I'm 5 feet, 130. It slides quite easily. Yeah, sliding is not lifting. Rolling is not lifting. All the family walked out together for lunch, about 25. Melody left with one friend she has here, the man that sits behind her, and his name is Alan. So did you all see the court TV? Let me show you that video. It was their walk on the burn pile, to the burn pile. Let me show it to you. So let me preface this by saying this came out yesterday. This is court TV walking around the property at Purcell Lane where the murder occurred. This happened the day the jury went to view, and this is their raw video.
You can come around me.
That's
Let me know if you see anybody getting off that bus.
That's the jury bus.
This was okay?
If you want to walk around,
Yes.
however
You
much
need to
you
walk
want.
around the burn pit.
That's obviously the judge. You're not seeing jurors. It's court TV. The jurors were there separately. They gave the media an opportunity.
Obviously, we're not going to go all the way down.
Again, this is not the jury. This is court TV's crew and the judge. Judge is going down with the media. It's not the jury. They take you up to the chicken coop. That's incorrect, Wybe. It sold for more than 800. Yes, it is usual for a judge to go to a crime scene when they have the visual. He has to. Isn't that extremely freaking powerful?
Were you expecting these charges?
Dude. I was like, some powerful stuff there. Again, that was not the jury. The jury bus was ahead, but they were not at the property in that area at the same time. The people who bought the house did get a good deal. I think it sold for $975 and it's valued now for more than $2 million. You love the coop and the run. It's cute. They added to that coop. That was one of the things when they when the judge instructed them on this view, about the changes to the property from the time it was when the murder occurred. I have absolutely no idea about their taxes. I didn't look up anything about the animals and the tax. I'm sure in Tallahassee it would be a tax write-off to have those kind of animals. It was a beautiful property. You love the smell in Hershey, PA. I know. You don't smell it now. You only smell the peanuts, which the Reese's factory is outside of the town. Like, there's no true town. It's actually Dairy Township. It's just formerly known as Hershey. But Reese's is on the outskirts of where the park is and the pretty downtown. Chicken's on camera, or it's a mistrial. Or a tarp. It was probably a tarp because a tarp will slide. You know, I have a tarp on my roof now. When she dragged him on a sheet or a blanket, she wasn't worried about pulling him without getting bruises, just my guess. It was an expensive for him to keep up. Paula says that was helpful to see. I'm glad that helped. It helped me last night when I was watching it. Did anyone wonder if the victim was shot at the burn pile? There was at least one shot in the house because there was blood, a lot of blood. And there was a hole dug in the wall. So there was some belief that maybe she dug into the wall to get the bullet out. Frenchie Connection says, I watched that video twice and it is absolutely doable, especially when you are angry like that. Patty, what's your thought? Guilty. How long? Life. I'm pretty guilty, but having sat on jurors, don't think it will be quick like Charlie or Sarah. I don't know. I don't know. I was surprised Sarah's was 20 minutes with food. It was an hour and a half with food, so I don't know. But I think she's guilty. Means, motive, opportunity. She was the only one in the house. There's only one home. She had to call Scott home. She didn't run into Scott and say, hey, you put your dad on a spit. He's in the burn pile roasting. She didn't catch up on him. She's blaming him, but she never said she was home. She was home the whole time. Did she ever say she heard gunshots or didn't hear gunshots? Or like, Scott did it and I heard gunshots, so it had to be Scott? None of that. Means, motive, opportunity. Scott was not there. Rusty was not there. She had the equipment. She knew how to use the equipment. Now, it's different if I'm doing it. I don't know how to use the equipment. But if I'm pissed enough, I can drag whatever I need to. That was fake turf. And they said that in the judge mentions it to the jury because they put in a putting grass. Carolyn says, I believe she's guilty, but I think it's going to be a hung jury. I don't. It'll either be innocent or guilty. I thought the burn pile was further from the house too, Carrie, until Murder by Maestro a while back pointed it out to me and how close it was between the house and the barn. Patty is a straight shooter. When I don't know something, I'll tell you. If I haven't figured something out, like ask me to pick paint. It's a long, hard roll. Picking paint is probably the worst thing I am ever asked to do because I have no idea. Give me 3, I'll pick 1. But if you give me 10, I'm screwed. Off topic, Thumper. If anyone wants to Pennsylvania chocolate, try Wilbur chocolate. I mentioned that. Lidditz, PA, original competitor of Hershey and still makes original recipe Wilbur Buds. It has a rosebud at the bottom of at the base of what is a Hershey Kiss, but Milton Hershey clearly stole the idea from the Wilbur family. Doris believes it's guilty, guilty, guilty. She didn't think about looking for a bullet when she missed her adrenaline messiah. There's always something missed in a murder, always something. There was an incline she might have used to slip and slide. It's downhill from the house. Roseanne hopes it's a guilty verdict. Wybie says guilty as heck. Angela is saying Melody favorite theme is Go Big or Home. Melissa agrees she's guilty, but prosecutor needs to step up their passion. Hope Guy finishes the woman with bland in her closing. I believe he is going to be next. Rosemary says, I do know how to drive a tractor and an ATV. I have both and about Melody's height, weight, size. I do not. Do you know if they still make Clark bars in PA? Well, let me check. Do they? It was made in suburban Pittsburgh. They're currently made, nice, I love a Clark bar. They're currently made in Altoona-based Boyer Candy Company, so they are still made there. Nice. Patty, would you use a left-handed Range Rover? I can drive stick to this day, but I cannot drive stick with my left hand. So I would not have, I have a 93 Land Cruiser that's right side driving that got a new alternator last night and the battery's charging. And I would not be able to drive a stick with my left hand. It's only for decoration purposes only, my left hand. Nothing. You remember the rosebuds. Nice. Jersey Girl says, if I'm pissed enough, I can drive anything. And I've proven it. And I'm old and 4'11". I had an aunt. My grandmother's 4'11". I'm glad I'm tall. It could have gone either way. Renee says, if the chat room was the jury, we would have a quick verdict. It's pretty outside and they want to go play and get things done. Tammy says guilty. Moonchild, what do you want me to write here? Murder says, only just thought she used a revolver, meaning she had to take that spent bullet out manually. That's kind of weird. Was Melody offered a plea? Unknown. I don't see anything in the docket that says that he did that. Carolyn says, I don't think he died in the house. I don't either. I think she injured him in the house with one bullet, walked him or drove him with equipment at gunpoint, second bullet to chest, falls into fire. And she went back to bed to call her boyfriend. Clark bars are your favorite. I like them. My mom loved them. I like a Fifth Avenue too, which is the same idea. Hey, bossy Texas chick. I see Melody sitting at the defense table all these weeks. She's not somebody that I can picture rushing around doing anything. She seems like the sort of woman that takes her sweet time, but she wasn't. She wasn't. She was a busy farm girl. She grew up on a farm. I also think she forgot the bullet. I think she did too. But she had to basically drop it there. Thumper used to live in Lidditz. It's the cutest town. So cute. On days like that make the Wilbur Buds, they'd sell vanilla ice cream. The smell of chocolate was so strong you'd think you were eating chocolate ice cream. I had the pleasure of working when I was a nurse at the Masonic Homes, which is in Elizabethtown, Pennsylvania, which those Masonic homes were well ahead of their years. Their treatment for folks with dementia was decades ahead. And there's also a Mars factory in outside of Elizabethtown, PA, which is between Harrisburg and Lancaster. And my son-in-law worked there, and he would bring home fresh Three Musketeers, which are just bliss. I'm glad Scott was there in person to honor his dad. Where are the other children? Tammy says judge is back. Guilty on all charges. Interesting. Why didn't Melody just ask Gary for help getting in the horses that night? Yeah, that's what. Ooh, a chunky bar is lush with the raisins. Oh, God, you're killing me. Domestic coordinators come in all types, bossy. Beach bum Wesley. Is Amanda in the courtroom? Lori. Amanda is present with a white sweater, dark, thin stripes. Tiawa Bawa says guilty is charged. The only thing that may drag deliberation is they may be discussing how the body ends up on the burn pile in terms of phone calls. They have all that info. E-Town. Oh, I feel homesick this time of year a lot. E-Town is what Elizabethtown's called. I know. Lidditz is beautiful. There's a lot of cute towns around there. There's so much to do when you live up in the north. We don't have that in Tallahassee, but a day trip where you can go 45 minutes, be in a different town, different type of food, different stores. It's really nice. Well, my business partner, Scott, just bought a Range Rover. He did. He got a Range Rover Sport. It's really pretty. Oh, wow. That is definitely PA. That's Allentown area. Paula says when she grew up, her dad always hung a Moravian star. You don't know what a Moravian star is. Let me show you. They're beautiful. This is a Moravian star. Absolutely gorgeous. He's home. I wonder if Miss Martha's watching on a Recovery Addict. She needs to be coming over here because we love her. I love Martha. Poor thing. He's probably suffering really bad today. Florida is boring. Tallahassee's all whitewashed. And I don't mean like white people. Our ethnicity is actually more minority than it is Caucasian, but when you go to a town like Tallahassee, you expect Southern charm. There's none. No Southern charm. None. I can't wait to hear the rebuttal too, because I didn't get to hear anything. How did you get down south? How did I get here to Tallahassee? My first ex-husband moved me here. I originally moved to Florida because I wanted to be closer to my parents. My parents had moved here the previous year, and I was missing them. I have attachment disorder, and I was missing my parents dearly. So we moved. Not guilty on concealing a dead body. No evidence he was dead when he went on the burn pile. Lidditz was founded by the Moravians. BS says you work for C's Candy for the holiday season. We could eat as much candy as we wanted as long as it stayed in the building. They are all over PA and Ohio. I don't know that they're Amish. Let me see, because I don't know. It's a German star. It's the Moravian Boys School in Niesky, Germany. Hey, where's Wesley? Wesley would know this. They have their own church. It's the Moravian Church. Interesting. Wesley would know. Why isn't Rusty there? He's trying to avoid having to post bail later today. We're going in. Phones will be off while court is in session. Thank you, Wesley. We do have Spanish moss. It is beautiful. Rusty didn't go to the trial today for the same reason that the A's didn't go to their son's trial. I thought Martha Jane came across as genuine too. Doris says, I used to work at a homemade candy store. We were allowed to eat all the chocolate we wanted within reason. Rusty's in Jamaica. Moravian church members do not pay taxes. Good for them. Murder by Maestro. Let's go. See if the judge can hold it together. Please hit like. Please hit the like if you're joining us. I really appreciate it. Very much so. The poll, guilty 82%, hung 12%, not guilty 5%, and that was 472 votes. We have a lot of springs too. Yeah, but I don't really go outside much. I'm a shopper, not a fisher. Okay. I don't really go to the springs because I don't want to get a tick. And I've had one tick in my life and it was enough. And no, I'm really not. I'm a shopper, not a fisher. I can browse with the best of them. The bags were a stupid demonstration, Mealy says. Rusty's on a plane to Vietnam. Hey, Sandra, how are you? Please hit the like button, subscribe, and share. I think we have fun here. I mean, it is a trial. Kind of guilty, but would I buy a used John Deere from Rusty? Probably. He knows his John Deere tractors. We need 472 likes. Bless it, Roseanne. Bless it. More people here. Oh, thank you, YB. Thank you. I love our people. I don't know. I just do. It's just super fun hosting you all. I'm posting on Twitter. I know it's not Twitter anymore. I know. Welcome to everyone from Twitter. Thank you so much for following. Babs, I'm the only host that's not called you a troll. Well, I don't see that you are a troll, so I wouldn't call you one. Hey, Debbie Gibby, how are you? Boatloads of people. Yep, we have boatloads. Boatloads. Rusty and Harvey are pals, hang out at the strip club together. Can a Jewish person join the Moravian Church? I don't want to pay taxes. Aw, thank you, Frenchie. Thank you so very much. That's very nice of you. Thank you, Debbie. Thank you for being a moderator. Thank you for being a fabulous. All the moderators are fabulous, really, but very much thank you for helping while I was out. I really just appreciate it. Everyone's good team here. So you don't have to get rid of people when everyone's so nice to each other. Isn't that lovely? You don't have to put them in any detention center thing or fake punishments grown-ups have when they all talk nicely to each other. What is a hedonist? It's a resort in Jamaica where the swingers go. It's naked. It's dress code is optional. Wear a white towel. It's true. These trials are like an addiction, Rosemary. Rosemary, follow Rosemary around. She has some really great questions. You don't always know where she's headed. Like, you don't know if she's like pro-defense or pro-state. But fabulous questions. Thank you, Jill. I love it. I absolutely love it. People in my office don't seem to mind that's going on in here. People think it's funny that I'm doing it. I'm like, where else could I talk to 500 people and be an introvert? It's the most amazing thing that God ever created. And then speak to people all over the world. It's absolutely amazing what I get to do. It's just incredible. Bossy Texas chick says, Patty, I think you found the magic formula. Just hanging out, talking at you and to you with no annoying guests that we have to be nice to. I don't mind interviewing people. I just don't think I'm that good at it. I'm good at it on the radio when I can see them and they have cues about like question. But when I did it a couple times, people are like, you keep talking over them. Whatever. It's my show. But I think people get in the moment and they don't realize that you got to wrap it up, or they don't realize you got to finish a sentence. And so I find it very difficult. I find people who interview, I just need to get more practice at it. There was no gun. Well, then how the hell did he get shot and left on the burn pile? Rosemary says, thank you for letting me say what I think. I'm a healthy conversation with like-minded people. Thank you. Thanks for the compliment. Thank you, Rebecca. Oh, thank you. It's very nice. Mert, Birdwater. Good afternoon from Mexico. Mert, did you already tell me which part of Mexico you're in? Villanelle's boots. Hello. Sandra's not dressed yet. It's a human thing. It is a human thing. I do interrupt people. And when I'm interviewing you, if we give cues in the radio station so you know when to start, stop, and wrap up your comments, it's really hard to do it on a StreamYard. But I think I'm good at interviewing. I'm just not great at interviewing. Hope you will cover the Lee Gilly trial whenever it happens. My friend knows the family. Let me look it up. The bullet was lodged in his rib. Isn't this already much longer than 30 minutes? The pizza must have been late. Ask Weaver like it's JFK Jr. about the magic bullet theory. Well, here we go. All rise except for this one. I'm going to mute myself.
All right, go ahead.
pointing people out to you. I'll do it.
There was one thing that Melody Farris was very good at, and that is betraying everyone close to her. I went through testimony of her children in this case, even Amanda. She tore our family apart. Mom became hostile, aggressive, demanding money. Even Amanda said, there was manipulation. I should have been more angry at her. And Chris Farris, when he was asked, how do you feel about your mom committing this crime when your daughter was possibly at home? I think it's sick and twisted. He didn't say, oh, I don't think she would do that. These are her children. But as you sit here, she is trying to blame them for this crime. Those are her kids. Let that sink in. She has thrown both her sons, a son-in-law, under the bus for this crime. The murder of her husband, who she betrayed the most. She didn't only take away their father, but she took away a grandfather. She took away a big part of Bern Foreman. But the only thing he was to her was in the way. When she's faced with the reality and the consequences of what she did, the first thing she does, serves up her kids on a silver platter, parades it all around the courtroom. But the evidence in this case doesn't point to a single one of them. This is Gary. He is not a pile of bags of fertilizer. He's a man. It's offensive to compare man to bags of dirt. Now the defense wants you to believe she's just the unluckiest woman ever. There was blood found in her home. There was a bullet found in her home. She was framed. It was planted. That's not reasonable. She just happened to also be having a long-standing affair with a man who's searching for wedding rings less than a week before Gary Farris is murdered. They want you to think that's a coincidence? Man, they're in for it because there's a long list of coincidences if that's the game they're playing. If that's what they're trying to get at. Not only that, but she just so happened to be taking care of a woman who owned a .38 snub-nosed revolver in a leather holster that her son saw in the basement of her home. Another coincidence? No, ladies and gentlemen, that's called evidence. They want you to think there's an individual, innocent, reasonable explanation for all of the incriminating evidence against her. That it's a giant conspiracy. That the gunshot wounds didn't kill him? Use your common sense and reason. Now let's briefly talk about Scott, then we're going to get into the evidence that incriminates Melody Farris. When you think about Scott Farris, think about the manner in which he testified. Think about how he was corroborated, not only by the witnesses in this case, but the digital evidence. The digital evidence proves he was truthful about everything he did that week. Tuesday, Wednesday, Thursday. And he's corroborated by Martha Barton, because you know what? He didn't know that Martha Barton had a gun, a 38 snub-nose revolver in a leather holster. And a huge piece of evidence. He knew Melody best. He knew his parents. He knew their dynamic. He knew that. Melody never had a credit card. He knew that Melody was angry. He was there when she slammed that plate down and said, God, I can't wait till the day he's dead. He saw that. The day before his father was murdered. He knew that Melody despised Gary. And he would get caught in the middle. He just wanted to bury his head in the sand and be like, let me do my work, keep me out of the marriage problems. But the second he knew his father was in that burn pile, they want to get on him for taking charge. You know what you learn in the military? To take charge. To take action. That's all he knew. That was ingrained in his mind. We need to call 911. We need to get the girls out of here so they're not traumatized for the rest of their lives. And we need to get to the bottom of this and get to the truth. Let's talk about lack of motive for Scott. He was completely relied. He completely relied on his father for everything. His livelihood, the place he lived, the money. Why would he take that away? He would have nothing left. Melody would kick him out immediately. He also knew, forgot to mention, Melody disappeared every week to go see Rusty. He knew that. One of her motives. And he didn't have access to a 38 revolver or own one. Think about this. Scott committed this crime. There's no way she wouldn't know about it. She was home the whole time. Law enforcement didn't blue star the barn because nobody saw blood in the barn. They blue starred where there was physical blood. No blood found in the barn. They didn't have to. The bullet was in the house. Gary was on the burn pile.
What happens when you leave a plate? Forget to take it upstairs. A minor temper tantrum. Of course, I had supper tonight and it was 6 for me, so I'm sure I'll be feeling poorly here within minutes. But we'll see.
There was testimony about Gary talking about Melody poisoning him. We didn't admit that or get that in evidence because we think he was poisoned. That shows his state of mind. That shows he knew Melody would kill him if it came down to it. She's the only one that would have. And he knew she wanted him dead. She's clearly poisoning me. Supper was fixed for me. I'm probably going to feel bad. And that was after her slamming that plate down on the ground in frustration because he left a dirty plate in the theater or his bedroom or wherever. It's not normal behavior. That corroborated Scott. So this might be because I'm a millennial, but I always read that first line as, do you have my credit card? Because my phone always fixes due to so, and it just irritates me. But read it however you wish. Gary to Scott, do you have my credit card? So you have my credit card. Choose one. Yes. Hang on to it as if your life depended on it. Is that what you tell someone who you want to cut off? No. That's what you tell someone you trust to keep the credit card away from her. He relied on Scott. Probably a little too much for this dynamic for him, between him and Melody. Probably shouldn't have gotten Scott involved, but here he is. He lives on the property. It's natural. He says, okay, and then he says, she makes me go shopping with her because she keeps saying the other card is turned off, her debit card. The girlfriend of her boyfriend, Rusty Barton, sent me several disturbing emails last night. This is in October of 2017. She is spending dime of my money. Either she is spending every dime of my money or she won't spend every, I don't know. Something about spending his money. Things will change dramatically. You need to pursue a job soon. He's not telling Scott to pursue a job because he wants him off the property. He's telling Scott to pursue a job because something's about to go down. He's about to leave her. He's had it. But this was almost a year before his death. Melody wanted everyone to believe after Gary was murdered that Scott was some big, scary dude that everyone should be afraid of because he's got PTSD or whatever, and he's just a big guy, so you should fear him. She even had Amanda and Chad change locks on that house. But if you go through these text messages, which is S. Farris 5, State's Exhibit, it's all their text messages post-offense when they were living on the property together. You know what she did? She relied on Scott. She left him keys under the rug to get into the house, but then turned around and told people he stole stuff out of the house. That's not two-faced. That's not malicious. I don't know what is. That's your own son. You don't leave a key under a rug for someone you think wants to kill you or frame you, or someone you think killed your husband. Oh, keys on the rug. Come on in. One more thing about Scott. Mr. Fogus mentioned the oath we take as prosecutors. It is our duty to uphold the law without fear, favor, or affection. There is no evidence that points to Scott in this case. You don't think if there was evidence Scott did something in this case that he wouldn't be sitting at that table with Melody? Sure, make our job easier. I'm not going to indict someone where there's no evidence he committed a crime. let's talk about a little about the Farris family history. In the beginning of this trial, y'all probably were wondering why we walked through every child's history and experience growing up in all these different houses and states, and what their dad was like when they were younger, what their mom was like when they were younger. Then you realized how far back and how deep this goes. This is not a simple family. This is not a simple case. But in order to fully understand the dynamics of this family, you had to hear all of that history. You know that this is from Emily's wedding. I'm going to talk about a little bit of build up to the day of July 3rd, 2018. You've got Ted Wiley, that affair, about 8 years before Gary's death. That changed the dynamic of Gary and Melody's relationship greatly. He totally took her off the finances. He was like, you want to take out all of the money I had set aside for taxes? Great, I'm going to take you off all the accounts. You want to come back and try to work this out? Come home, leave Ted, who, by the way, was dating Gary's sister for like 20 years before she decided to hook up with him. 2010, he dismissed the divorce that he filed. Martha Jane had her surgery in 2014. Okay, the kid said that things seemed fine between 2010 and 2014. Seemed fine. Martha Jane had her surgery, and that's when the affair begins with Rusty Barton. Emily's wedding was 2 years later. She flaunted that relationship in front of people that night. She didn't care. She had no conservative spirit about that whatsoever. And Gary had to pretend like it didn't bother him that night because his daughter was getting married. It was supposed to be the best night of her life, but you know who couldn't help but make it about her? Melody Farris. Chris testified that Gary was so upset, he said, that's the last time Melody's going to embarrass me. Then you have in 2016, Martha tells Melody about the location of her revolver. You also have in 2016, Melody telling Gary, I hope you die alone and a gruesome death. And remember, Terry Braswell, this was Terry Braswell's phone, and he had her burner phone number. This was a phone she thought nobody would ever see the inside of. She's not saying that type of stuff on her 9029 number. And then Terry says, he's gonna push you over the edge. And she says, I know, and that scares me. I told him finally to go where could not even see or hear him. It would be in his best interest. She knew she had no self-control. She hated him that much. September 2017, she gallivants out to Jamaica with Rusty. Meanwhile, she sends her debit card through the mail to Sherry Cooper to run it in Minnesota because she told everybody she was in Minnesota. Poor Sherry. She had some guilt about that. She's like, I don't know why I did that. That was stupid. Don't forget, Melody betrays every person and uses every person close to her for her own benefit. She even, you saw, and I've already mentioned this, you saw Amanda's reaction to those text messages. Oof. She did not like being used like that. Gary receives an email from Christina Grant. Just FYI, your wife and Rusty Barton have been lovers for 3 years. I'll give it. Oh, supposed to black out Miss Grant's email. Sorry. I'll give it to her. She's the only one who's bringing this to light. Everyone else sweeping it under the rug. Christina's like, nah, y'all ain't gonna get away with this. That's when Gary texts Scott about the credit card. Hang on to it as if your life depended on it. March 2018, Gary sends Melody this text message. Your profligate spending must stop. He says in the middle there, between you, Chris, and Scott, I can't keep up. You treat me like I don't exist, which is offensive, typo, my typo, given how you repeatedly betray me. Gary's in the hospital in April of 2018. Meanwhile, she's telling Rusty Barton he has like esophageal cancer and he's spitting up blood and he's on his deathbed. Even Chris said she made it sound like he was bad. And then he shows up to the hospital and Gary's like, what's that look on your face for? And he's like, I thought you were like real bad. And he was fine. He walked out of that hospital, went back to his Mountain Dew. And that's when he tells Chris, I think Melody's poisoning me. Again, that goes to his state of mind. This was all amping up. He knew something was off. June was a big month, 2018. June 6th, DirecTV comes to the house, and yes, please look at those chats, because Gary says, hey, come to the house real quick. I need to show you the issue so you know what issues when they get here. That's when DirecTV comes, that's when Scott sees that as well. Again, this corroborates Scott. He could have said, I don't know where I saw that gun. I don't know. He knew when he saw it. He was like, actually, I was looking for a remote, which makes perfect sense. He's looking in drawers for the remote to figure out the TV, for the TV guy. That's completely reasonable and natural. He's opening drawers and he's like, oh, that's weird. A gun that looks just like the one Martha Barton described. June 25th. Rusty searches in his phone plain gold wedding band. You'll see text messages from Melody to him. Plain gold wedding band, that was their thing. And then Gary's birthday, Jenna sees a revolver. Jenna has no dog in this fight. Her and Chris aren't even together anymore. They don't talk. She has no dog in this fight. She didn't want to be here talking about this. No motive to lie. Then on June 28th, Melody learns about the beach trip, which is supposed to be that Saturday. That's also not a coincidence. Then the text messages. To Emily and Amanda. These are two separate messages that she sent to two separate people expressing how angry she was that Gary got a condo for Chris and Jenna. Not a reasonable reaction. She was over it. I'm taking measures to stop this insanity. No one thought these would be the measures. But here we are. Because the next day, Gary's murdered. Again, not another coincidence. Let's talk about her motive. That first text message, I was shocked when Sherry told me you had a boyfriend, but don't blame me. From Terry Braswell to Melody. Plain gold wedding band. That's when he searches on his phone. Rusty does. This note, Crown XO, March 31st, 2014. She made a note in her phone about Rusty's favorite drink. So we know that corroborates the timeline of their relationship. And then these messages on the side here from August 4th and 5th, that's between her and Rusty. That's a month after her husband was found murdered and burned on a burn pit on her own property, who she claims that her son killed. Meanwhile, she's over here forever. We need us. I need you. All. You don't get more motive than that. Except she had more. All right. This is all the money she would get if Gary died accidentally. Add all those up. Okay, $4.15 million. Now, the defense wants you to believe she didn't know about it. You know what you do know? You know that she goes in his phone when he's not around. You know that she cleans that house. You know she's not stupid. She knew about his profit sharing. She called the office and asked about it. She knows where that money goes. She, again, consider the source. She is going around pretending like she's asking Emily, what am I going to do? What am I going to do if something happens to your dad? They're the ones that stood up here that said his money is her money. We all know that's true when you're married. It's either going to go to her or the kids. Probably all four. Naturally, without a will, that house was hers. You cannot tell me she thought she was going to be broke. It's ridiculous. Afterwards, it was always about money. Melody was demanding money. She was trying to get as much money as possible. She didn't think that when he was found dead, all the finances would be frozen. She didn't think they found a bullet in his rib either. I was terrified I would be broke. Man, your husband's a millionaire. And here we have it, the condo. This is Hayes 55. Did you talk to Chris about his beach trip? What beach trip? He wants to take the girls down there the weekend after the 4th. Let him take them. I haven't gotten past him standing on my porch telling me he was gonna beat me unrecognizable, and then only time he wanted to see me again was when they put me in a box on the ground. Or that he continues to take money every month, of which you do nothing about. She's blaming Gary for that. There is something terribly wrong with not being able to take a beach trip with the grandkids without so much drama. I guess such a trip is not exciting enough for someone like you. Man, he knew his wife, didn't he? July 2nd. I got Gary's phone. He booked and paid for the condo for Chris and Jenna. I'm beyond furious. Amanda, oh, big surprise, right? Always there in the mom's corner. I had to put times on this one because this is ridiculous. Melanie, did you book a condo for Chris and Jenna? Trying to like trap him? It's your husband. Be like, hey, I got your phone, so you booked this condo. You don't want to talk to me about that? Actually, he did talk to you about it. He invited you on a trip. You said no. I booked one for me and the girls as well. That's how manipulative and conniving she was. And you remember, in Lindsay Harris's presentation, you saw the group chat among Amanda, Gary, and Melody about she was making a photography appointment, Amanda. She invited both her parents, and Gary said, I'm going to the beach. Melody chats her on the side. This is your time to ask him. Thanks for the invite. Manipulation, conniving, deceit. That's what she's about. Again, these text messages. The top one is a little bright. Melody to Emily. I have had it. I'm taking measures to stop this insanity. This was July 2nd. That's her message to Amanda Farris. This is the last straw with him. All right. I want to get into the timeline of events. These phone calls, these are all the phone calls that she had with Rusty on the 3rd in the evening. I didn't go before that. We know Chris and Addison stopped by the house in the evening. We know Gary went out to eat and came home around 9:30. And don't forget, John Lambert heard gunshots between 9 and 10 p.m. that night. They talked for an hour and 14 minutes at 11:45 p.m. But they talked for 5 minutes at 11:28. The call in between that is the one to Scott, 11:34, when Scott calls when he gets back home. Because, you know, she has to tell Scott to come home. She calls him and she's like, what time are you going to be home? The horses got out. And I want you to think about this. In her statements to Detective Hayes and Detective Kuykendall, she talks about these horses getting out. I think it starts like before dinner. And then it starts with like one horse, right? And then for some reason, she's still chasing horses 3 hours later, but then it goes to two horses. And then she's like, oh, but then the third one got out after that. Inconsistent. You weren't chasing horses. You were murdering your husband. She had to call Scott because she didn't know what time he'd be home. She had to call Scott to see what time he'd be home. Because then, when she says, well, the horses got out, and he's like, okay, I'm coming home. She's like, well, I got them put up. Okay, then why are you calling? It doesn't make sense. The horses are the cover-up. when she calls Scott, Scott's all the way up there at the lake. She calls him at 10:52. What time are you gonna be home? All those calls with Rusty in between. I want to talk about this notification. At 12:24 a.m., the morning of the 4th, so the night of the 3rd, the night Gary is killed, she uses her debit card to purchase minutes on Straight Talk. Y'all heard a lot of testimony. 1, about how she doesn't have a credit card. 2, about how Gary would get financial alerts for all of her purchases. Lindsay testified, Ms. Harris, testified. This was the only alert that popped up in his email, in his phone, for Straight Talk. That's not a coincidence. She knew Gary was dead. So using her debit card to blast that she has a Straight Talk phone, not a problem.
She said, Gary is in the burn pile. No, she said, he is in the burn pile. And I said, what? And she said, he's in the burn pile. And I said, do not say another word and do not tell me anything. I do not need to know.
That's what that 220 call was about. Now, again, believe what you want about Rusty. We all know he knew more than he came in here and told you. We all know that. We're not stupid. They talked for an hour and 35 minutes at 11 whatever, and then another 35 minutes at 2:20 a.m. But that's all he was willing to give. But that's enough. And you know that that's how it happened because he gave you the context and he told you when that call happened. Mr. Ray talked about Detective Botsong using this open source document or program for the CPAP machine. All right, the date is the 3rd. It ends at 7:48 a.m. That's the last data for that CPAP machine for Gary Farris going to sleep. Now, you got the raw records too. Look at that. Oh, 7:48 a.m. It's the same. The data, the raw data, shows he never, ever went to sleep the night of the 3rd. Now, I want to talk about this map. All right. All right, see where that dot is? And that's Gary's phone. The morning of the 4th at 6:37 a.m. till 7:21 a.m. Right there at that burn pile. We know Gary's dead. And we know it goes from the house to the burn pile. You'll have that with you in the jury room. And then it goes back to the house. $7:58, $8:21, $9:05, it's back at the house. She's on the phone with Rusty all morning. And you know Scott's location during this time, it's in here. He left for the lake. He was 20 minutes away The only one home was Melody. That phone was either on Melody or on Gary's dead body. But you know who wasn't there? Scott. Melody was by herself. You know Rusty wasn't there because she's on the phone with him the whole time. Well, and you heard testimony that he was actually in Tennessee, but also. We know what time she left for the lake. She left 12:47 p.m. She puts that location Amanda sends her into her maps and heads out to the lake. Now, the thing about Dr. Pope's testimony in that 24-hour window, she said that that was dependent upon the fuel. And you heard testimony that that burn pile was huge. You know what she did? She lit that burn pile and she left. The 3 calls with Rusty Barton, the evening of the 3rd and the morning of the 4th, total more than the other 15 calls that they've ever had between those hours. Again, that's not a coincidence. She was freaking out because she just killed her husband and had to figure out what to do with him. You know who she turned to? Rusty. What do I do? Yeah, I'm going to talk about her activity. The 3rd. The 7th, September 7th, 2017, September 30th, 2017, and the 3rd, July 3rd, 2018. Those are the 3 days she had the most activity between. This is a 1 hour period, 1 hour from 11 p.m. to midnight, okay? Now, we talked about Jamaica, the one on the 7th, that was probably a data dump, okay? All right, fine, let's get rid of it. 2. The 2 most active nights she has ever had in a year are gallivanting about Broadway when she's out in Nashville with Chad and Amanda, and the night she murdered her husband. That tracks. That makes sense. That's reasonable. This is also not a coincidence. I want to talk about the money. We know Melody didn't have a credit card. The only card she had was a debit card. And that card is the one that ended in 0078. The one Scott used at that ATM that morning that he got from the house and brought back. Okay, there's that ATM withdrawal. That's the one he brought back to his mom. Even Melody says about Scott, and he has a credit card. I don't even have that. We know that. That 0078 card is her only card. Until law enforcement empties her wallet. That card on the right, ending in 1727. That's the card Gary got mailed to his office less than a month before his murder. That was a new credit card. That's his office address and that Bank of America activity alert. And that's her transaction at Walmart the morning of July 5th, before Gary's remains were discovered. Oh yeah, by the way, the trip to Walmart that she doesn't mention to police ever, that she says she's literally interviewed on the 5th and on the 6th. Leaves it out, says she's just, I don't know, cleaning up after the girls, lays in bed. Why don't you talk about this trip to Walmart? Look, she even activated a phone card. What was so important you had to run out to Walmart that morning? Could it be to restock on cleaning supplies? Is that why you didn't want law enforcement to know you went to Walmart? Or because you spent $450 on a credit card that you didn't have until you took it out of your dead husband's wallet? Both. She needed to wash those towels. She needed to Clorox that floor. She bought a lot of soap, a lot of bleach. And we know it was her because she bought wine and showed her ID. Let's talk about the truth of July 5th, 2018. Melody is actually the one who pointed out Gary's remains to Scott. And yet she's letting everybody gallivant around saying, Scott found him, Scott found him. That's not true. And she knows it. She's the one who told police also that corroborated Scott. I said, hey, did you put a goat in the fire? That was her pointing out the remains to Scott. Because if you don't have a body, you don't get the money. She knew he had to be found. Melody actually knew the night before that the girls couldn't find him. Addison said that. She wasn't concerned. And yet she pretends like the morning of the day she didn't know he was missing. Melody only started looking when Amanda got there. She was sitting on the stoop, just like, hey, yeah, they can't find Gary. Okay, well, how long do you know about this? Actually, since last night. Well, that would be the wrong answer. That would make her suspicious. And when Amanda described the events on the 5th, boy, were those vastly different from everybody else's. Thing about it, and what got me was she was like, nobody asked me. Weren't you told not to talk to the police? You were the one who didn't want to tell what happened. So then you live with your mom for 2 years and decide to tell what happened, and by then, you've been completely tainted. Scott testified he went to go look for the CPAP and the gun that he used for duck hunting to see if maybe he's out duck hunting. All those comments about a missing gun, that's not true. He didn't mention that till after he went in the basement, thought to look for that 38, saw it was gone. Then he came up and was like, oh, yeah, by the way, this 38's missing. He didn't mention a missing gun before that. Think about the source of all that information. That's Melody being vindictive and planting thoughts in her daughter's head. On the 5th, when you go back and you hear Melody's statements, on the 5th, man, she tried everything. Scott's health issues, suicide, Chris steals money. Here's the thing. Here's how it went down, okay? I have a picture of an octopus up there. Do you know what an octopus does when it feels threatened? It squirts ink in the water to escape. The closer she felt like she was getting into trouble, the more she felt threatened. She starts spewing all this ink about her kids. She even talks about Chris Payne. He wasn't even in the state. I mean, she does not care who she throws under the bus to save herself. It is actually insane. And it's such a reach. Scott likes to shoot guns. Okay. Chris takes money. Okay, well, he was in Buckhead, so this is going nowhere. And then the suicide. It's funny because she says, no, he wasn't suicidal. And then when she feels threatened, she's like, oh, well, yeah, no, he used to be suicidal before we got married. Once she realized that the jig was up, ooh, she was frantic. The only person she didn't throw under the bus was Amanda. Because she'll need one child to support her. She just needs one. It's all about what she wants, what she needs. It's not about anyone else. She prided herself on her house and her things. She liked her things. She wanted to keep her house immaculate. She talked about that. She decorated it to a T. Not my style, but you know, to each their own. And yet, it was pretty dirty on the 5th. Let's talk about the blood. Don't forget that Deputy Riley walked in that house and there was a candle burning by the basement door. No place for a candle to burn. And it smelled like bleach. We've got Gary's blood right there on that basement floor. The defense wants you to believe these are all different sources of different things. That's not reasonable. We've got a blood trail. And it goes from the top of those basement stairs, where that attempted cleanup is, down the stairs, into the basement. See that big bottom splotch? That's those stains right there on the left. That's blood. Those evidence markers that were Gary's blood, right along this trail. That's in the basement, in front of the bar. It is not reasonable to think that there is a legal justification for all of that. That's not reasonable. What's reasonable is that's a crime scene. Because we have a man who was shot twice at least, burning in the burn pile behind this house. To think otherwise is to seek doubt. And that is not worthy. Means and opportunity. They had a lot of stuff. They had a lot of farm equipment. You know who's farm girl? Melody Farris. And she's, you know what? She gets it done. She's determined. She's self-sufficient. And you know what really motivates someone? Getting caught for murder. It wouldn't have been easy for anyone to move that body. Not Scott by himself, not Chris by himself. Anyone would have needed something. And you know what? It's okay if you all think different ways in which she moved his body. One of you could think she used the tractor. One of you could think she used the RTV. One of you could think she literally just got down and rolled him there. It was all downhill, you saw. One of you could think she tied him up like a deer to the back of the RTV and dragged him over there. But he ended up on that burn pile. And a ferry didn't put him there. A murder ferry didn't put him there. No one else. There is no evidence anyone else was on that property. And to think differently is to seek doubt. She was in good shape, people. She had no choice but to move him, or she would have been caught literally red-handed. She's not stupid. That's why we're here today. Now we're going to talk about guns. Scott doesn't have a pistol. We introduced that. She is a self-proclaimed not a bad shot. She told that to Terry. That means she's shot guns before. And remember, she's a farm girl. And a 38 revolver, pretty easy to shoot. Martha Jane. Ooh, they're mad about Martha Jane. She is, as Mr. Fogus said, God-fearing. She needed to be right with God. She's not going to lie to you. She noticed that gun was missing after Gary's murder. And it's reasonable for her to think that we can put a gun in her hand for this murder. It's reasonable for her to think that. But it wasn't until she realized we didn't have a murder weapon, and she was like, oh, they need my help. I gotta say something. And it was in a leather holster. You know who that gives credibility to? Scott. We know he was shot at least 2 times. These were shot from the same gun. And no, they're not consistent with the 38 bullets found in Scott's apartment. They're just not. And they're not consistent with a 357 or whatever other gun they think may be involved. No. It's consistent with 38 special revolvers. Not 357. I'm going to talk about Melody's lies. She was interviewed by Sergeant Hayes and Sergeant Kuykendall. And when she was told that her husband of almost 39 years was shot, do you remember what her question was? Do you know what kind of bullet? That would not have even crossed my mind to ask. No suspicion. What do you mean he was shot? What? I thought he just, what do you mean? He had health issues. She's not worthy of belief. She lied to them about Ted Wiley. She lied to them about her phone. She lied to them about Rusty Barton, her XO tattoo, going to Jamaica with Rusty, Gary going out to eat on the 3rd. She never mentioned that. Because you know what? She was waiting inside that house with her gun, ready to confront him. She lied about going to Walmart. She lied about how much money I spent nothing. Man, profligate spending? I had to look that word up. She kept saying Chris booked a beach trip. No. She knew Gary booked that, but she wanted to blame Chris. Gary being on his deathbed, coughing up blood. Occam's razor, y'all. The simplest answer is the truth. The simplest answer in this case is where all this evidence points, and that is to Melody Walker Farris. It points to no one else. This is not a series of coincidences. She was not framed. She's not the unluckiest woman in the world. And again, there is not a series of justifiable reasons that explain her conduct. There's just not. And there aren't justifiable explanations to explain the evidence. July 24th, Rusty says, to law enforcement, she told me he's in the burn pile. She's arrested a year later, booked into Cherokee County. They have a jail call on June 24th, and whoop, on June 25th, he recants that statement. Y'all, there's Melody Farris for you. That manipulation. She knew Rusty was her Achilles heel in this case. She knew that. She had to shut it down. You know what she was really hoping? This is how she wanted it to go down. She knew the only way out of this marriage was murder. She knew that. I don't know why she thought that, but that is what she knew. Murdering the father of her children. She was hoping his body, being on that burn pile, would be chalked up to a health episode. She didn't think the sheriff's office would find that bullet in his rib. She just didn't. That's clear. She didn't think there would be blood left in her home. She didn't think anyone would be looking for it. She didn't think law enforcement would be all over that house. Well, we found it. And we kept digging, and we found more and more and more. We found out about your affairs, your disdain for your husband, your obsession with money and things and materialism. She never once encouraged law enforcement to find the person that actually did this. She didn't think this is how any of this would play out. She manipulated her own mother to have an affair with Ted Wiley. She manipulated Martha to have an affair with Rusty. She manipulated Amanda to go with her to continue her affairs with Rusty. She manipulated Emily. She would go to Nashville to see Emily and disappear to go see Rusty. She used all of the people in her life. She used Sherry Cooper to see Rusty. She used Rusty to try to get away with murder. She used Scott Farris to try to get away with murder. She used Chris Farris to try to get away with murder. And she used Gary throughout the entire marriage. She had the motive, she had the means, and she's the only one who had those. And she's the only one who had the opportunity. There is no evidence this was Scott. Mr. Fogus told you in opening we had to shrink the world. That's what he meant. And that's what we did. There is no evidence that she had help. That would make our job a lot easier. Her help was on the phone. It was Rusty Barton. There is no evidence it was anyone else. This evidence demands a verdict of guilty. Do not reward this criminal behavior. Do not reward her for almost succeeding in burning up her husband's body, unrecognizable to the point where doctors, forensic anthropologists cannot determine if any organs in his body had trauma. And no, you cannot tell me that there were no injuries on bones. Half those bones were gone. What you know is there was a bullet in his body and a bullet found in the basement with his DNA on it, and a gun that went missing from Martha Barton, who she had access to. She knew where that gun was. Do not reward her for almost concealing successfully the death, the gruesome death of her husband. Hold her accountable. Melody was the only one who wanted him dead. She was the only one who would benefit from him being gone. She was the only one repeatedly betraying him. There are no games here. Murder is not a chess game. It is malicious. And Gary did not deserve this. The last thing he saw was staring down the barrel of a .38 revolver in the hands of his bitter wife, who was constantly betraying him. But this was the ultimate betrayal. Hold her accountable. You are the voice of Cherokee County in this case. You have the evidence to convict her beyond a reasonable doubt. We have proven it to you, and you have it. It's in the form of thousands of exhibits, testimony from the stand, audio, a lot of audio. If there is something you want to see or hear that you can't find back there, you send a note out to the judge. Do not reward her for being a smart criminal. You are the voice of Cherokee County that we do not tolerate this in this county. You do not get to shoot and mutilate your life partner. You don't get to take away the grandfather of your grandchildren. That is not your choice to make. The ultimate betrayal. Gary will not walk through that door. And that's because she took him off this planet. Find her guilty of all the counts in this indictment. The evidence and the law demand it.
All right, I want everyone in the audience to stay where you are. Jurors, y'all can take a 15-minute break, and then I'll give you the charge. That's going to be probably 40 to 50 minutes. Everybody, y'all can stand up if you want to, but y'all stay where you are. All right, I'm going to address the audience for a minute, and folks in the back, y'all can keep rolling while I do this. The first thing I'm going to do is I feel compelled to talk to the folks out in TV land for a minute and defend the state of Georgia and clarify something Mr. Weaver brought up in his closing arguments, and that is Georgia has had a constitution since we were enabled as a state. In fact, we've had somewhere between 10 and 12. No one's exactly certain how many, and I'm not a constitutional scholar. But the most recent version of our Constitution was adopted in 1983. That wasn't the first version of our Constitution. Yes. All right. Yeah, well, the folks that are watching us in New Zealand don't. All right. All right. Couple of ground rules for those of you in the audience. We're going to start charge. All right. This is something that's not covered in TVs and movies very often. It is long and it is relatively boring. But there are two times that I close my courtroom and don't let people come in and out. One is during adoptions, which are closed proceedings. Two is when I am charging a jury. It is critically important that the jury hear the instructions that I'm giving them. The bailiff will be manning the door and will not let anyone in or out. We're going to take a 15-minute break, and if y'all want to take a break, please do. If you want to remain with us after the break is over, I'm going to give 5-minute warning and I'm going to start. But once I start, you will not be allowed back in the courtroom. So if you don't want to remain for the entire 45-minute closing charge, then don't come in. Most of the lawyers in the building that would usually come in and watch a closing, because they typically do, are watching them on the internet so they can tune out to this part because it's, like I said, relatively boring. All right, that's really all I need to tell y'all. I need the bailiffs to move the easels. I've asked the clerk to give me a copy of the indictment. Tracy needs to find my copy of the stipulation because it disappeared. That was up here. And yeah, I was going to read them off mine and not the one for the jury. All right, with that, we'll be in recess for 12 minutes or so. I haven't checked it back, but fold it down, put it on the floor, move it out of the way. Move the lectern, please. Yes. I'm gonna move the remote control off my stack of books here.
Alan, Melody, unknown. That's Scott. This is Scott's. There you go.
Stick that on the table. The copy of Mr. Weaver, the copy of the indictment I have down there isn't signed, but that's typically what I want them out of the way completely. We've got a juror in that back corner, so I want them taken down, moved out of the way, tossed, whatever.
about 26, 37 o'clock tonight.
I'll let them go as long as they want. I doubt they'll want to stay late, but they, I'll just try to get a feel from them. I'll check. I'm not going to run them off.
Sorry, I didn't mean to post that, Renee. That bot. She literally just made her account like 5 minutes ago. So I'm not worrying about Susie right now. If her account was older, that would be one thing, but it wasn't. Frenchie says her toxic trait is that I always start with guilty and they have to convince me they're innocent. This trial is outside of Alpharetta in Canton, Georgia, Cherokee County Courthouse. I don't know if she's defense plan or not. I don't even know what that means. I don't know enough about YouTube and the bots of YouTube, whatever. But when somebody pops in that hasn't been in a chat, has literally made no comments at all, because you can, now I know how to do that, to go into an account and see how many comments they've made, through how many channels they subscribe to. She didn't, she wasn't, and she hasn't. That's all I have to say about Susie Q. I'm moving on. But I'm finally happy the state said means, motive, and opportunity, because much to other people, he was the only person at the house. The CPAP shows he never put the mask on. He never made it to the bedroom. Next is the charge, which is the jury instructions. Okay, well, I'll make a poll for that. I don't know, troll bot. I don't know how YouTube works it, but when it's a brand new account, when they've not subscribed to anybody else, when they've not made comments on anyone else, and they just come in here and are absolutely contrary, calling people lazy, and they're the ones who did it, the whole thing. It's just an odd situation. So I'm just not, another day I might be in the mood to handle it better, just not today. Every day is different, and I'm not good at dealing with this today. The judge is going to come back in 15 minutes, and he's going to read the jury instructions. I have to leave here at like 3:15 again to go back to the radio station to record for another guest. I hope they have instructions a verdict. They could have it today. It's only 2:30. He's going to be done at 3:30. It could be back in a minute. 15 means 30. That is true. That John Luke Weaver said, I don't understand it either, but he's the one who told her to sit. Well, she's a grown-ass woman. She could stand if she wants. We're peers. No, you're not peers. You're not peers. My freak flag, yeah. Jury instructions are boring. Yeah, their teleprompter was picking up the hard one. I hit it off, but I turned it off here. It could be anybody. That's true, though. Let me go see. Let me go check something out. Let me go in on the fly. What was his name? Recovery addict. See if there's anyone there with that name. Mm-mm. No, no one in that one. I hope we have a verdict tonight. Oh, did you go look too? Did you look, YB? Yeah. When somebody's that new and that kind of like lazy, like just caustic, it's even in my experience watching other people's trials, that tends to be somebody who's not real in real life. Thumper's explanation. Yeah, I mean, if somebody does a brand new account and they've never subscribed to anyone else, although I love to be flattered, I can't be in this case. Especially after the last month in my life. It's can't trust anyone. Hummingbird, nice to meet you. Hummingbird says, came to the trial very late, but it reeks of guilt. Standing does show respect. And it is the South. It's not like you're in, Michigan. No, they read it after. No, they read it after. Jury instructions are post-closing. EB says, I have a 5-hour drive to Canton tomorrow. I hope the verdict comes in. Well, what I've learned about taking the stand since the Charlie A trial is if I were on trial, I wouldn't take the stand even if I was innocent, because the appellate courts look on that as, and you're convicted, look on it sometimes as perjury. Melody probably doesn't pull over for a funeral procession either. I wonder where Rusty is too. Rusty is running. I wonder if Rusty has a Facebook page. I didn't look at his. Oh. Nope, that's not him. It's a different Rusty. I'm looking. Tullahoma. Oh my God. I hate when Facebook frickin' updates everything and makes it difficult to find people. His name is Roy Barton, right? Isn't he Roy Barton that becomes Rusty? Nope. Let's see if Martha Jane kept hers up. Bless her heart. She has more followers now. Everything is gone on Martha Jane's poor little. So sad. Anyone know if Rusty still has the other girlfriend? Once you're defendant in any criminal case, your chance of being found guilty is 94% on a not guilty plea. Well, I was thinking it would be higher. It would be higher than that. Frenchie wants pizza. I'm not, and I, ooh, where'd it go? He probably scrubbed it. I didn't see it before the trial. I looked then too. True crime and wine. Hey, Stone Girl. Motel 6 with one of his many bots. What was that girl's name? Christine Grant, right? She was Christine Grant. She was pissed. I couldn't believe they showed that email. I hope she doesn't use it anymore. You have to assume she was in Tullahoma. What do you think Melody's response was to finding out that Rusty was sleeping with someone else? What do you think? Think she was pissed? I found her. Pretty sure. Let's see. Maybe not. Apparently she doesn't live in Tullahoma anymore. Stop it. Were they living together? Hold on. Is this why he moved in with his sister? I mean, his daughter? Pardon me while I snoop. Talk amongst yourselves. Remember he had to move in with his, he was living with his daughter. Yes. Get this. Get this. So Rusty, Roy Barton, and Christine were actually living together. And that is why she owned the home. I'm so fast. That is why he had to move in with the daughter. Did anyone catch that? Anyone see what I just said? Anybody? I don't know why I hadn't thought of that before. He was living with the daughter because he had been living with Christine, and Christine dumped him because of Melody. That's why she was so pissed. They were living in the same house on Bel Air in Tullahoma. Can't make this shizzle up. Unbelievable. What a dog. What a dog. Martha Jane's even more upset now. What a dog. Yeah, but I mean, he was a dog to Christine. Roseanne said Rusty was living with someone, but Melody was married. 6 of one, half a dozen of the other. If you're living with someone, you're expecting them to stay faithful. And then he's paying for the Motel 8 because that's what the guys do. Rusty did think a lot of himself. Last name of Christine? I'm not going to say it. They already showed it on the trial. She's innocent, poor thing. Beach Bum, tell us what the jury thought of the... Let me see if she's sent a text. Oh, you do? Yeah, I say shizzle a lot. You glad I missed whatever? So what did the jury think of? Her name was Christina. Yeah, they were looking at black diamonds. Court Laura 60. Debbie says Rusty must not be selling many tractors. He's 71 now. Oh, okay. Thank you, Lana. They pronounce it Tullahoma. Well, that makes sense. Francis, Rusty better worry about his mess falling off. I bet it doesn't work anymore. Oops, they're back. Just so you know, I'm leaving in like 40 minutes. I got to be at the radio station at 4. He did scrub it. That's what I was wondering. I thought, I bet Melody was pissed he had another woman. Don't you remember Melody?
ability to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law that I am giving you in this charge to the facts as you find them to be. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is either established or disproved. Evidence includes all the testimony of the witnesses and any exhibits admitted during the trial and any stipulations. Evidence does not include the indictment, the plea of not guilty, the opening or closing remarks of the attorneys, or any of the questions asked by the attorneys. Evidence may be direct, circumstantial, or both. Direct evidence is that which may be seen or heard, or otherwise directly sensed, such as by smell or taste or touch. It may be brought into court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence, by inference, points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. The law does not require a higher or greater degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence. You would be authorized to convict only if the evidence, whether by direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. The parties have entered into stipulations that have been approved by the court, and I read that to you earlier, but I'm going to read it to you again now. In this case, the parties have entered into stipulations that have been approved by the court. The named victim in this case, the decedent whose remains were found on the property of 2155 Purcell Lane, Alpharetta, Cherokee County, Georgia, 30004, on July 5th, 2018, is Gary Wayne Farris with his date of birth. All of the phone records collected throughout the investigation related to Gary Wayne Farris's death are authentic and shall be admissible at trial. All the Google records obtained through the investigation related to Gary Wayne Farris's death are authentic and shall be admissible at trial. All the records obtained for cell phone towers, AT&T and Verizon during the investigation into Gary Wayne Farris's death are authentic and shall be admissible at trial. 5, all the digital evidence, including cell phone data obtained, extracted, searched, or analyzed during the investigation into Gary Wayne Farris's death is authentic. All the reports and any opinions thereof from the GBI, Division of Forensic Sciences, are authentic and shall be admissible at trial. And you'll have a copy of those stipulations as part of the evidence as well. Where parties stipulate facts, that is the nature of evidence. You must take that fact or those facts as a given without the necessity of further proof. You make all decisions based on the evidence in this case. Where parties stipulate to testimony, documents, or exhibits only, this is in the nature of evidence. You may take that testimony as if it were given in court, and you may rely on it if you find it credible. However, either party may dispute such testimony by other evidence. You make all decisions based on the evidence in this case. The jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their special training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinion based upon that training and experience. You are not required to accept the testimony of any witness, expert or otherwise. To impeach a witness is to show that that witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. The credibility of a witness may be attacked by disproving the facts to which the witness testified. The credibility of a witness may also be attacked by showing bias toward one party or another. This may be shown with evidence of specific instances of conduct of that witness in question that may relate to that witness's bias. In determining the credibility of any witnesses whose credibility have been attacked, as I have just described, in any testimony by that witness or witnesses in court, you may consider evidence offered to support the credibility or believability of such witness that shows a lack of bias toward a party. The credibility of witness may be supported by other evidence, and you may consider such evidence in determining the credibility of a witness. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before this trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. There is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. Evidence relating to DNA comparison has been admitted for your consideration. Identification by DNA comparison is considered opinion evidence and is governed by the law concerning opinion testimony as it has been given to you. As opinion testimony, evidence relating to DNA comparison is dependent upon many factors. Among the factors are the credibility, believability, and accuracy of the witnesses who were involved with the process of obtaining, identifying, preserving, recording, and maintaining the physical evidence, and upon the accuracy and validity of the testing procedures themselves that were used to form such opinions. All of these issues are matters for you, the jury, to consider and determine. It is for you to determine what weight, if any, you will give to the evidence relating to DNA comparison in your decision in this case. Sometimes evidence is admitted for a limited purpose. Such evidence may be considered by the jury for the sole issue or purpose for which that evidence is limited and not for any other purpose. Evidence of prior difficulties or lack thereof between the defendant and the alleged victim, or between the defendant and a witness or witnesses, has been admitted for the sole purpose of illustrating, if it does, the state of feeling between the defendant and the alleged victim or witnesses, or the reasonableness of any alleged fears by the defendant or any alleged victim or witness. Whether this evidence illustrates such matters is a matter solely for you, the jury, to determine, but you are not to consider such evidence for any other purpose. The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. However, the defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. A statement the defendant allegedly made has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary. In order for a statement to be voluntary, the statement must be freely and willingly given and without coercion, duress, threats, use of violence, fear of injury, or any suggestion or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. The burden of proof is upon the state to establish that the statement was voluntary, that is, freely and willingly made. If you do not find the statement was voluntary, you may not consider it for any other purpose. You should consider with great care and caution the evidence of any out-of-court statement allegedly made by the defendant offered by the state. The jury may believe any such statement in whole or in part, believing that which you find to be true and rejecting that which you find to be untrue. You alone have the duty to apply the general rules for testing the believability of witnesses and to decide what weight should be given to all or any part of such evidence. A defendant's out-of-court statement that is not supported by any other evidence is not sufficient to justify a conviction, even if you believe the unsupported statement. This defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act and intention. Intent is an essential element of any crime and must be proven by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you believe that it existed from the proven facts before you. Intent may be inferred from proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is a natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by a statute. The defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to, that the acts of a person of sound mind and discretion are the product of that person's will. A person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make any such inference or inferences is a matter solely within the discretion of the jury. Knowledge on the part of the defendant that the crime of making a false statement was being committed and the defendant knowingly and intentionally participated in commission of such crime must be proven by the state beyond a reasonable doubt. If you find from the evidence in this case that the defendant had no knowledge that that crime was being committed, or that the defendant did not knowingly intentionally commit the offense of making a false statement, then it would be your duty to acquit the defendant. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crime of making a false statement was being committed and that the defendant knowingly and intentionally participated in the commission of it, then you would be authorized to convict the defendant of that charge. The mere presence of the defendant at the scene of a crime without more does not authorize a conviction. The evidence must show that the defendant committed the crime or participated in its commission. For malice murder, the state must prove that the defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred, rather is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with a deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be a significant provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or killing and moved the defendant to do it, that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated assault is a felony. You may find the defendant guilty of felony murder if you believe that she caused the death of another person by committing the felony of aggravated assault, regardless of whether she intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. When a defendant unlawfully injures another person, you may find that the injury caused the other person's death only if the state proved that the injury was itself the cause of death, or directly and significantly contributed to the cause of death, or significantly sped up the death, even though the death would have eventually occurred anyway. A person commits an assault when that person attempts to commit a violent injury to the person of another. For aggravated assault, the state must prove that the defendant assaulted another person with a deadly weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. For concealing the death of another, the state must prove that the defendant concealed the death of another person, which hindered the discovery of whether that person was unlawfully killed. A person commits the offense of false statements when that person knowingly and willfully falsifies, conceals, or covers up by any trick, scheme, or device a material fact, makes a false, fictitious, or fraudulent statement or representation, or makes or uses any false writing or document, knowing the same to contain any false, fictitious, or fraudulent statement or entry in any manner within the jurisdiction of any department or agency of state government or of the government of any county, city, or other political subdivision of this state. The law provides that criminal actions shall be tried in the county in which the crime was committed. Venue, that is, the crime was committed in Cherokee County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in this indictment, just as any other element of the offenses. Venue must be proved by direct or circumstantial evidence, or both. All right, you'll be provided a verdict form for each offense the defendant is charged with committing. Each count is to be considered separately. For each count and on the fly. For each count on the verdict form, if after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt the defendant in Cherokee County, Georgia, did commit the offenses on the date of the indictment, you will be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. For each count on the verdict form, if you do not believe that the defendant is guilty, or if you have any reasonable doubt as to the defendant's guilt, then it will be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. As I mentioned, you'll be given a verdict form. This is the verdict form. It has each of the counts charged in the indictment on the verdict form, and there is a box, guilty or not guilty. Circle or check one only for each charge. And then at the bottom is a place for the foreperson signature If you'll also put your name below the signature line and date it. I think there's some pens back there. Make sure you have a pen if you're the foreman and you're filling out the verdict form. I had a few juries do it with the pencils that we provided you, and I decided that was probably not a good idea. By no ruling or comment or action that the court has made during the progress of this trial, nor any ruling in any pretrial hearing, has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Your verdict should be a true verdict based upon your opinion of the evidence, according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. You are only concerned with the guilt or innocence of the defendant. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to select one of your number to act as foreperson. That person will preside over your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about this case, including persons or places or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communications or research using cell phones, text messaging, websites, blogs, or social media of any kind. As I instructed y'all before, y'all will take your device, the bailiffs will take up your devices and put them in a box, and they will be in the hallway during the course of your deliberations. We will take a short break while we gather everything up to present to you to take out to the jury room. During that period of time, y'all have an opportunity to call home. Again, you can tell them that y'all are starting your deliberations, that they will hear from you at the end of the day when y'all break or when y'all reach a verdict. I will give you additional instructions when we break for the day if y'all decide to come back and deliberate tomorrow. I've had jurors in the same situation as you who have decided after 6 hours of closing argument and instructions from the court that y'all are done and want to come back and start fresh in the morning. If that is what y'all want to do, that is perfectly fine. If y'all want to stay here till 8 o'clock or 10 o'clock or 2:30, as I told y'all I had a jury do, y'all are welcome to do that. If y'all stay late, we'll order some food for you if y'all choose to do that. I've also had folks that have been deliberating for some period of time who decide that they want to get away from each other, go off site, have dinner on their own, and then come back and kind of refresh. Again, I will leave that up to y'all's decision, and how you want to deliberate, I will, for the most part, leave up to you. There is a lot of evidence in this case. The attorneys and I have gone through it, made sure that y'all have everything you're supposed to have. Do we have a list of the exhibits for them? All right. All right. All right. There's a list to help guide you through all the evidence as best we can. For, I think, all of the photographs, there are hard copy printouts of the photographs, so you don't have to ask to see those again. If you want to see videos or hear recordings, despite my technological prowess, I have been trying to come up with a way for y'all to view digital evidence in the back. Nobody else other than me trusts that process, and so therefore we haven't done it yet. That is still something I intend to do before I retire. But for now, if y'all need to review any digital evidence, you will have to request it in writing, and you will come back in here and we will put it on the screen or put it on the audio. Along with that, if you have any questions, you can, again, through your foreman, you will give me those questions in writing to the bailiff. I will do my best to answer those questions as best as I can. You may not like my answers. For any communication between you and the court, it has to be in writing through the bailiff. Now, I will probably, if y'all are here this evening around 6:30, I will ask the bailiff to check in on y'all and see if y'all want to stick around for a little bit longer and whether you want us to order you dinner. That will be the extent of the conversations that I have with you through the bailiff, will be really timing. Any communication to me needs to be in writing from you. If you have requests, put them in writing, make a list. Let me explain to you what that process will look like. It will take, the district attorneys are going to go upstairs to their office. The defense attorneys have a conference room out front. They're going to be there. The DAs are going to be up there. I'm going to be in the back, and the folks in the courtroom are going to kind of scatter. When y'all send me a question, I have to notify the attorneys. I've also told the media I will inform them so that they can cover that part of the proceeding. It's going to take 15 or 20 minutes for me to gather everybody up. Maybe a little shorter than that, but it will take 15 or 20 minutes before I can respond to you, because I will have to discuss with the lawyers what we are going to tell you or show you or get it pulled up on the screen. Therefore, I suggest that if you have any requests or any questions, that you give me more than one if you have more than one thing you want to look at or think about or ask questions about. Again, you may not like my responses. I will tell you this because this is generally a question that I get. We want to see X, Y, or Z evidence that was not admitted during the trial. The evidence is closed. There will be no other evidence that you will receive other than what you've been given. The only thing that you have that you don't know about is we took the video that the media recorded while we did the run through of the jury view. If you want to see that video, that is an exhibit that y'all have not been presented, but we have agreed that y'all can view that, and that is part of the evidence. And if you would like to rewatch the lawyers and I walking through the jury view, y'all are welcome to request that. It will take a few minutes for us to discuss what we're going to present to y'all. Then y'all will come back out and we'll go over that. I will generally give you an opportunity to, especially if you're wanting to see other evidence, to huddle up and talk to each other real quick and see if there's something else you want to see. The recordings are lengthy. If there's a specific portion of a specific recording that you want to hear, and you know one of you took notes and know about whichever part y'all want to listen to, give us that information as best you can, and we will attempt to find it. We will try to figure out what you're asking for. We will play it for you, and then we will ask you if that is in fact what you wanted us to play for you. If it's not, then we will try to find it. Y'all understand that process? All right. Whatever your verdict is, it must be unanimous. That is agreed to by all. The verdict must be in writing and signed by one of your members as foreperson, dated, and returned to be published in open court. Georgia law does not provide for the alternate jurors to sit in on the deliberations of the jury. In a few minutes, we will bring the alternates back. We will identify which one of you are the alternates, bring y'all back in here, and I will give you additional instructions. Based upon the length of this case and how long I anticipate y'all may take in your deliberations, the alternate jurors will not be, y'all will still be on call and still be on the jury and will not be able to work, etc. I will give y'all more instructions about that. If an alternate juror is needed, deliberations actually begin anew, and y'all essentially start back over with an alternate. As I've indicated to y'all, once the case is yours, you'll be in control of when you will deliberate and when you won't. Once you go back to the jury room, I'll ask you to turn off your devices, not to turn them back on until your verdict is presented. If I intend to take a recess for lunch, if we take a break, I will let y'all know that we're taking a break. I know the lawyers are probably tired, but they took a bite to eat. They have sandwiches or whatever back in their offices. And so we are not going to take a longer lunch break. We're going to be on call while y'all are working this afternoon if y'all choose to do that. If y'all need to take a short walk down the hall, that's fine. You don't have to let me know that. If y'all want to take a break and go off site, then y'all need to ask for us to be able to do that. If a group of y'all want to go downstairs in the short period of time after I send y'all out, that would be a good time if someone wants to go downstairs and get a Coke. If someone needs to go take a smoke break, I will give y'all 15 minutes or so to take a short break before y'all begin your deliberations. During that time, we will try to get the alternate jurors back in here quickly. So no one go anywhere until I tell y'all to. We'll bring the alternates back in. I'll give them some instructions on what they will do for the rest of the day and the rest of your deliberations. In order for y'all to deliberate, the following things must occur. There must only be 12 of you. You all must be in the jury room. You must have all of the evidence, which includes the indictment, the stipulations, and the verdict form. Unless all of those things are present, you may not discuss the case whatsoever. So if one of you goes to the bathroom, y'all stop talking. If one of you goes down and has a smoke break, y'all don't talk about the case. Until all the evidence is gathered and presented to you outside, y'all don't discuss the case. Do not touch these once you turn them off. During the break, you can call home. I've given you that instruction, but I'm telling you again. If there is something you need, ask for it in writing from the bailiff. I have a calculator up here. We have a large writing pad if you want that. If you want the easel, the writing pad, some markers, I'm going to send those out for you anyway. But if there's anything else like that that you want, ask for it. Don't try to obtain it on your own. All right? With that, y'all step out in the hallway for a moment. You can make your phone calls. We'll identify the alternates and bring them back in here.
This was on my desk.
You had it.
I did have it.
I told you it was up here.
Would you like to keep it
I knew I'd lost it somewhere.
for the court hearing? Or do you want us to keep it
You
over
just
here?
hold on a moment.
All right. Our alternate jurors are 91. Let me make sure that I think I know what y'all are asking that I think you're wanting, which is all the boards and the piece of paper. Is that correct? Okay. Now, some of those were not introduced as evidence and are just demonstrative of the testimony. However, the lawyers have all agreed that if it will help y'all, that they don't have a problem with sending out to you. So we're going to send each of those out to you. Ms. Frankish is putting exhibit stickers on them so that we can refer to them. But y'all have asked for the family tree, the interview dates, and the aerial shots of the photos. So that's all the things that have been on the board all trial, right? And y'all aren't asking to watch a flyover or anything of the property at this point. Okay. All right. I also understand that y'all want to break at 5 o'clock. I'm not going to bring y'all back in here in 10 minutes to then dismiss you for the day. So here's what I'm going to do. I'm going to give y'all the instructions for when y'all want to be dismissed, and y'all can be dismissed between now and 5 o'clock whenever y'all decide to leave. Okay. So if y'all want to go in the back and then leave, that's fine. If y'all want to go back and talk for another 10, 15 minutes and then leave, that's fine as well. Everything that I have told, we are at the most critical stage of this trial in which y'all have the case. Everything that I've told you thus far, do not talk to anyone about the case, look up anything about the case, Google anything about the case. Y'all will get your phones back. We're not going to keep them from you for the rest of the week, so y'all can have them. But when you come back tomorrow, please make sure you give them to the bailiffs and turn them off. We will not do anything in the morning to ramp back up. Do y'all want to start at 9 o'clock? Do you want to start at 8:30? Do you want to start at 10? 9 o'clock. We're still going to, until, I guess we need to keep, we can get rid of 4 of the cones, I guess. But we will still have parking assigned for y'all, which if y'all saw how bad it was Monday was a good thing. So we'll still have parking for y'all. Someone asked the bailiffs about lunch. We don't typically do lunches while y'all are deliberating. I usually do it the first day, like today. I expect that by lunchtime tomorrow, y'all probably want to go get some fresh air and go away. Y'all are welcome to eat lunch together. Y'all are welcome to go about your own business. But what's the rule while y'all are outside of the jury room eating lunch? There you go. Fantastic. All right. We will take your devices up in the morning. The bailiffs will be waiting for you just like they have been throughout the trial. Someone will be at the end of the hallway. Again, y'all all show up. When you're all here, then y'all can begin deliberating. All right. So any questions about any of that or what your responsibilities are going forward?
Just important on, I guess, the parking, not parking garage side, but the ground level side. There was media out there filming.
All right. So, well, y'all going to be coming and going from the building since y'all have parking here. So y'all be going out the back door. So y'all shouldn't have anything to worry about, but they may be talking to some folks outside. I've asked them as best they can to do that in front of the building instead of the back of the building. All right. With that, we're going to give those exhibits. Yes. If you go ahead, Ms. Frankish.
Farris 11, which is the aerial house with the red pin in it. Case 60 with the black push pin in it. And then case 59, which is the Lakeview aerial. States demonstrative 1, the family tree, and states demonstrative 2, Rusty Barton interview dates.
No objection.
All right. We'll send those out to you. And again, y'all can, we sent the calendar out with the first one because there's a smaller version of the calendar. Oh yeah. Do y'all want the big one? We'll give you the big one too. All right. All right. With that, y'all can be excused back to the jury room. Again, when y'all decide to break for the afternoon, then y'all can just leave. All right. Thank you. All right, Shane, here you go. So, Mr. Roberts, now you decide to join us. Right.
right? It's a self-serving comment. The reality is he was like, ooh, that's too close to the road. I'm going to bring him over there. And he continued to do what he was doing over there, where he got them undressed or he had them undressed, and then he had her dress again later after he did whatever he was going to do. And he might have just been like, ooh, I don't know if I want to get completely undressed now because there's people moving around. Man, this is awesome. I mean, just, horrible situation, but it's awesome to have this kind of facts. And guess what, everybody? There isn't a soul out there other than the defense team that has known that white van drove by there. Okay, Richard Allen, and they didn't know that until after his confessions. Okay, it's crazy. It's amazing. Richard Allen was not aware of the 202 van that he saw. And how crazy is that anyways? I mean, see, here's the thing is, when you're arrested for a crime, you don't start false confessing after you're arrested. It's usually a false confession that leads to an arrest. And then after they look at the evidence, they go, well, you couldn't have done it. This isn't what happened. And then they go, okay, this is just a false confession. That's not what's happening here. This guy was arrested because of the evidence, and then he starts confessing. You see how there's a difference? People want to say, oh, it was the prison, everybody. It was so mean in there. Now the defense is going to come up with stuff. Hey, Karen. Yeah, the bullet is a fact. Yeah. So are there people in here that still think Richard Allen's innocent? Like, really? Like, is that a thought that you're having? I sure am, Gray. He's innocent till proven guilty, you bastard. God damn. You got to be kidding me. You got to be kidding me now. A van is driving on that road, and he saw it, and it was verified as driving by. He's the only one that would know that, especially at that time frame. That's amazing. Because the information that I had, and this is after the confessions, was that it was at like 3 o'clock is when he got off work, and maybe he drove by at 3:30. Well, that wasn't even right. So it wasn't jiving in my head, really. It made sense that a van drove by, and then after doing everything, he kills them, and he leaves at that time. But his story, see, this is what's so amazing to me because I know this case. Watch this. The 3:30 time worked really well. He was at the crime scene doing his thing, right? He was doing his thing. And all of a sudden, a van drives by, and it's really close. You can see it from up there, and he goes, holy shit. He panics, kills him, and he leaves. It works, right? It works. It's right the right time and everything. Except the crazy part is his confession it doesn't work with that. He says he goes down the hill. He was going to assault them. And then a van drove by, and he panicked, and he took him across the creek. And I was like, wait a minute, that doesn't work with the van because they're down the hill at like 2:15, 2:20. They're down here, walking around, probably hear it by 2:22-ish. And now it turns out the van drove by right around that time frame. And that's why he took them across the creek. You see how that is huge? Because now it's like this thing that nobody even knew. None of the YouTubers or anybody talking about it had the timing of that. And guess what? Brad Weber's vehicle. Now, here's what the defense is going to do. I know it's actually better than before, isn't it, Fig Sauls? And Fig Sauls is the guy that told me all about this. I said it on the previous live. He's the one that got like a tip on that information. He had the 3 o'clock to 3:30 time frame by a good source, and it turns out it was actually 2:02. But here's what the defense is going to do. You remember their theory, right? There's a car driving on the private drive we think the girls got into. Oh, and by the way, Brad Weber's bullet wasn't excluded from matching the ejection marks. Remember that part? So now they're going to start, casting doubt. Could it have been? Well, he got off work at 2:02, right? He cannot be bridge guy. Okay. So he's excluded, but the defense is going to try to muck it up and try to use him. Okay. But he's absolutely excluded factually from this, because Bridge Guy is seen at 2:13, and there's no chance in hell he could be back home at that time. Yeah, no, it's. I mean, I just started talking to Fig Sauls maybe like, I don't know, year and a half ago, and he's just been. It's been amazing. It's cool having like a colleague type, somebody that you could consider that, and you're just really working through the information and putting out the factual stuff and seeing things for what they are, and that is what is. It's cool. There's so many. There's. I get called a bad actor by a bunch of trolls out there, but I'm not that person. I'm not. They do that because they're trying to hide their own shame for themselves. And this channel, over the years, has put together information that has been accurate and really, really close to what's happening. And I'm absolutely proud of it. I'm proud of all the work that we do on the side as well, and we'll continue to do for as long as people want to support and watch my videos because we kick some ass. It'd be cool if I did this for another 20 years and we give away $1 million. Who the hell knows? Maybe it'd be quicker to reach there because we'd be doing so well here that it'd be easy. Don't know. I don't know, man. It's amazing. Yeah, well, the van stuff is, like I said before, Fig Sauls told me about it, I don't know, a few months back. Seemed like it was early summer time-ish. Maybe, I don't know, 4 or 5 months ago or something. And it's just something I mentioned, like on a passing, like, hey, maybe there's a car that drove by, you guys, maybe a van of some, giving little hints here and there. And I don't even know how many people are watching right now. It's just, let's see, I gotta go live, hit the button. And see, I'm one of the few channels that would actually understand the significance of what we're looking at. Right? There's a lot of new people. They're doing a great job covering it, but they don't have the context behind the scenes. They don't know what's going on, all the stuff. And this is one of those moments. It's amazing. Grady, you remember when we found out about the sticks? I'm trying to compare to, he confessed. Yeah, I mean, maybe the sticks, you're thinking, the sticks were in the Odin document. He would have known about the sticks for the entire time that he had a lawyer, but it sounds like the confessions, even when he said he covered them with sticks, was before any of that. Well, he did have a lawyer, though. He had a lawyer at that time. Yeah, so, I mean, I would say the van is something that only he would know. Now, maybe the defense will try to come up with something that mitigates that. I do not know. Well, hey, we told him about that, so he just threw it into the story. I don't know. What do you think about that, Fig Sauls? Because even in his confession, he says he covered them with sticks. Is that something, too, that might be like, wow, so he even knew about this? I mean, the public didn't really know about the sticks until the Odin document came out. We heard about, leaves and things like that. But now it sounds like that he said it more specifically like sticks and branches, that kind of thing. I don't know exactly when. I think the public heard about branches being laid on there in the Odin document, which was last year in September. Brad Weber and Rick Allen played pool at the same pool hall. I wonder if that's how Rick knew Kay was out of town. Oh, interesting. I don't know. Yeah, and is that their property, by the way? Is that Kay Weber's property in that corner? Because across the river is obviously Ron Logan's property. I know, I just said that, Karen. Yeah, I just said that. Right. So is that Kay Weber's property? Because I know a lot of landowners, they own land and it goes down into these areas. They just don't own the bridge itself. or where the railroad tracks used to be right there. You know, these railroad tracks, old ones, they used to go all the way out like this and literally runs into. I mean, I actually at one point was wondering if this is how the killer escaped. Me and some friends were wondering. Because look at this. Richard Allen lives right there, right? You walk down this road, and then look at, I mean, it's so close. You just walk down this road, and you walk through the woods right here. You go all the way down through the woods, and then boom, you're right at the end of the bridge here. Isn't that weird? Yeah, well, they didn't know that he was covered with. They didn't know that there was branches laid out in a diagram, Jay Lee, years ago. That's not true. People didn't know that. They thought maybe covered with leaves and little things like that. Nobody knew that. Is that the private drive leads to Kay Weber's property, but does she have the property below down here too? Okay, they own that one. So the corner would have been their property also down here, perhaps, right? I know that my friend Beth had the map of the area there. All right, so now let's do it again. Let's do we'll do this again. Watch this. So people showing up again. 12:43, the girls are right there. They effectively they are proof that Richard Allen's second story of being there at 12 and leaving at 1:30 is bogus. They were there the whole time, didn't see him until they're right here at 1:26. Richard Allen drives by in his black Ford Focus, parks at the abandoned CPS building. Then those girls then see the man that is in Libby's video, and that's Richard Allen. He admits to seeing them, and they saw him. He said he saw 3 girls, so he saw 3 of the 4 that were walking. And then Richard Allen continues on. Those girls then walk this direction. Then Betsy Blair goes underneath there and sees them at like 1:45. And that proves that the girl, I think Rayleigh, who said, oh, I think I left at 2:15, she just got it wrong because she sees them as she's driving underneath there at 1:45. Then she drives around and parks here at the, she drives by the Hoosier Harvest store and then parks right here across from the Mears property. And there's Betsy Blair. 2 minutes after her, Abby and Libby get dropped off, and there they are. But Betsy Blair comes down here, turns around at the barriers, which is 111 feet, not 50, as said at trial. Then she turns around. Oh, wait, I got to get this. Hold on. All right. There you go. Sorry about that. I was related to everything, but. All right, I'm going to do this again. I'm going to do it again. I'm going to do it again. 12:43. Boom. The girls go to the bench at 1:26. Then they head this direction, and Richard Allen's vehicle just after 1:26 drives by the Hoosier Hardware Store at 1:27, parks at the abandoned CPS building. Richard Allen gets out of the car, and he passes them. They see him, and he sees them. Then the girls, after they cross this direction, Betsy Blair sees them up above, all four of them. Then then Betsy Blair drives over across from the Mears property, parks her car. Then Betsy Blair gets out. Then Kelsey drives by, and Libby and Abby get out of the vehicle at 1:49. She passes the Hoosier Hardware Store. And they start walking down the trail. They're walking slower because they're just taking pictures, having fun, where Betsy Blair is exercising. She turns around at the barricade, which is 111 feet, not 50. So obviously her vision from 37 yards isn't going to be very clear, and her memory isn't that great. However, all of these victims, when shown the picture of the bridge guy, who was wearing exactly the same clothing that Richard Allen said he was wearing, they all said that the bridge guy is the person that they saw. So then Betsy Blair turns around and passes Abby and Libby. Then Abby and Libby are right here, and I think it's very possible that he was going to follow Betsy Blair, but then he turned around when he saw Abby and Libby, and then he followed them across the bridge. And then right down here in this corner, right here, he even mentions he cocked the gun up there. Right in this corner, he was going to assault them, in my opinion. Then a van drove by right here at like 2:30. Now, right around 2:30. Then he goes, oh shit. Then he has him get up and takes him across the creek. And this is where all the rest of the things happen. All right. Doesn't that make sense, everybody? It's crazy. It makes sense. So there you go. Hey, thanks, Laura Trini. What do you guys think? I mean, obviously the defense is going to do what they're going to do and try to mitigate things and do this and that and cast doubt on this and cast doubt on that. But how do you explain him knowing that a white van drove by there? Maybe they'll say, well, it was in the documents. They had that, when they interviewed him, he said he drove by. So Richard Allen saw that and he just sort of inserted it into his story. Yeah, that's why the false confessions after the fact just they don't make sense, man. They don't make sense. Who in the hell would do that? Hey, let me look up the evidence. Let me look it up. Okay, now look at it. Yeah, I did it, man. Here's all these things. People do false confessions that lead to their arrest, and then eventually the investigators realize it's false because nothing matches. You don't falsely confess after you've been arrested and you're in jail for a while. Nobody does that. It's really rare. It is. Name me another case where after the fact, somebody confessed after they've already been arrested for something. And it's really not common at all. So, well, that's all I was going to tell you guys on the update. I think it's huge news. It's really strange how this is all... like when I heard this earlier and I thought, okay, there's going to be this van. It wasn't making sense for the new confession that he made. He says he saw a white van, but I was thinking, well, the timing doesn't work because he got home at 3:30. But guess what? He got home at 2:30. He drove by there. So that is just bombshell information, and it means a lot to people who actually know what they're looking at. Right? And everybody that's been watching this channel, the freaks, they know what we're looking at. And we call ourselves the freaks. So I'm not, derogatorily calling them that. In fact, my license plate even says that. Okay? Yeah, she's there. Yeah. Thank you, Nicole. I appreciate it. So definitely be coming back on later. Make sure to check out, I think she's the best one out there. Lauren on Hidden True Crime. We don't even have a deal set up or anything. A lot of people don't even like me that are over there. But I am doing this for the freaks. She's covering. I couldn't take notes like she is. She's doing notes where it's the second best thing to having transcripts. I mean, you know, she literally goes through the whole damn thing, and it's like you're there, okay? So, you know, got to call a spade, that kind of thing. So hopefully, you know, after that, I'm going to come over here, and after hearing everything in there, we'll put it all together over here. I know this stuff. I really do. So thank you all for being here. Want to say thank you to Mrs. Ryan, Cheryl, Sunshine Susie, Wonder Woman 77, Get Us Out From Under. Kay Left, new member. Then we've got Josh Shepard, Play-Doh, not Play-Doh, Bonjour Nancy, the Pam Pepper, Karen, Cormac Connigan, and then Bridget Bauman gifted a membership. Then Amanda Sue Day got a new membership, and All Things, Nicole, and Michelle Cox. Welcome. Man, this is just so amazing, this stuff, you guys. How are you feeling right now? Anybody? I mean, I just feel like, okay, now the shit's hitting the fan for Richard Allen, okay? It's poor Ricky, boy, that little schnookums, he's being yelled at while he's sitting there. Well, yeah, that's because he's the killer the whole damn time, you guys. He admitted it. He cannot be anybody other than the bridge guy. It's factually him. He has no out. Yeah. This is crazy. Anyways, we'll see you guys later. Hey, slow down, Bridget Bauman. Slow down, man. Slow down. Slow down. Anyways, we'll see you guys later. Oh, and by the way, I did listen to Copacabana on the break just to see, and it's just as bad after all these years. It is the worst song in the history of mankind. Thank you very much for watching. And as I always say, until next time, be safe out there. Coco. Jesus. Oh, Copa. I mean, Jesus, it's just the worst damn song I've ever seen. Oh, I'm still on.
Yeah, I've been doing this true crime thing for quite a while now.
Yeah, Mandy's a
And
good
during this
song.
whole time,
Lisa, I'll give you
I have
that.
not seen one person that is a crime dissector, flag rejector. I'm a certified human lie detector. Gonna get ya on a stretcher if you try and play me like an old projector. Crime sector is my nectar. Professor Gragel's gonna give another lecture. Crime collector.
Oh, come on, Plato. You can't be serious.
I'm always gonna be a pup protector. Fool the
Yeah, what the hell is she talking about? What the hell is she talking about?
with a vector.
I don't know, Mary Lou.
Inspector, with all respect, ya. Just remember I have a temple fucking check ya. I have no agenda. I'm no pretender. And I'll serve it to you straight without the blender. And in the end, I'm gonna send ya on a mission to reveal the true offender. Yeah, so I'll just get right back to work. All right, everybody? Talk to you.
Hey, Gray. I always liked Barry Manilow.
Then how come you stuttered when you said his name?
I mean, I always liked Barry Manilow.
National, but they
Is
don't.
it Manilow or
anymore,
Manilow?
And I'm like, you suck.
I don't know, Gray. That's a good question. Good night, everybody.
Oh my God, Mary Lou. Yeah, what is it? Is it Manlow or Manilow? You know, does it have that extra? All right, we'll see you guys later. Be safe out there. Wow.